Well, welcome everyone. We appreciate everyone that is in attendance for this stakeholder meeting to talk about TMV's proposed rules on abortion. As we said back in the March meeting, we're still kind of at the beginning of this process. The proposed language that was put out there has been open for comments for quite a while now, and we're still continuing to accept comments, and we will continue to accept comments. It wasn't limited just to 30 days, and we've received quite a few, and we've gone, have staff going through those. But one of the things we also talked about was how important it is to get more feedback and have this stakeholder meeting as an opportunity for the public to provide their comments to us. And so what we're going to do is give each person that has signed up to speak so far, we do have a sign-up sheet and an order that we'll go through, but each person will be given 4 minutes to make their comments to the board. And really what we're here to do today is to listen and to take all that feedback that you give us today and what we've received through the written comments and see what revisions may need to be made to the rules as we continue to go through the rulemaking process. So again, this feedback you're going to give us here is very important and something that we're going to take very seriously as we go through the revision process of this. Before we get started, though, I do want to turn it over to Dr. Zafran, who I believe has a few words as well.
Yeah, thank you, Brent. And first of all, I wanted to thank everybody who's joining today for taking some time out to help offer some comments and suggestions. As I said at the last board meeting, the rulemaking process is a very deliberate process. We do put our initial proposed rule out there, but the comment period is something that we do take very seriously. Your input, your suggestions are an important part of this process, and I just want to assure you that you have the undivided attention of myself. There's a couple of other board members on here, as well as the legal staff from the medical board. We are here to listen. There may be possibilities of us asking some clarifying questions, but we're going to try to hold to the timeline since there's a lot of you that would like to provide comments, and we want to make sure that everybody has that chance. Again, get your input. We will take all this. We will have our legal team look at it, make sure that we can see what suggestions we can potentially incorporate into our proposed rules as we are working toward deliberating it again at the next board meeting. So once again, thank you, and we look forward to a very informative morning and early afternoon.
Great. Thank you, Dr. Zafran. And so we'll get going here. And so first on our list is Steve Bresnan.
Any of you have mic and camera permissions now, so you're going to need to unmute on your end.
Mr. Bresnan, can you hear us? Trying to scan through the list of attendees real quick and see. Oh, there, I do see a name for him. Showing that it's still muted, though. Yep, see your hand up. Guess you're unable to unmute yourself so far.
There's a second hand up also, Ms. Fox, I believe. I wonder if there's a problem with them unmuting themselves.
I think how we've set it up is to keep kind of the disruptions down. Is cameras and mics are disabled until each person is called on to speak, so we don't get any kind of background noises inadvertently. but it looks like the controls should be opened up for Mr. Bresnan at this time. Okay, well, we'll kind of work through that issue. Next is Amy Bresnan. Are you able to unmute? All right, well, while this is maybe while they're working through their issues, let's move on to the third individual and see if we can get one of them to start working here. Dr. Valenti.
Morning. Can you hear me?
Yes, we can.
Good morning. My name is Dr. Joseph Valenti, and I'm a board certified OBGYN from Denton, Texas, and I'm chairman of the Texas Medical Association's Board of Trustees. TMA represents 57,000 physicians, residents, and medical students. Today, I'm here to relate our concerns with the Texas Medical Board's proposed rules regarding medical exceptions to abortions. I want to thank the board for taking on this enormous task. We know it's a challenge in every way, but the work you do could aid us in saving the lives of Texas women and ensuring their future fertility is preserved. The current rule proposal gives us concern about how to move forward with the practice of medicine in these clinical scenarios. Physicians must work within the standard of care, but under the current legal framework, they feel uncertain and confused, as well as afraid about how they can apply that standard of care while complying with the medical exceptions under the law. The proposed rule would do little to alleviate ongoing patient care concerns and physician confusion and fear of potential board discipline, civil liability, and even criminal prosecution. Thus, TMA respectfully opposes the rules as proposed. The goal as put forth in our comment letter is for the board to help ease this fear and confusion to ensure timely, medically appropriate care to women who are at risk of death or serious risk of substantial impairment of a major bodily function, including permanent loss of the ability to have children, i.e. future fertility. In situations that require difficult decisions of a medical necessary abortion, these babies are loved and wanted. And when a termination is required to save a woman's life and or her fertility, I can assure you the heartache and the tears are shared by all of us. Our comment letter addresses many issues. We're very concerned with the documentation and administrative requirements in the proposed rule potentially hindering our Hippocratic oath, limiting the use of our reasonable medical judgment, and delaying much needed life-saving and fertility-saving measures. We also want to make sure that the term ectopic pregnancy is clearly understood as something that can occur in any location, both inside and outside the uterus, and not just in the fallopian tubes. We also posed questions for clarification in our comments, and these include questions related to the definition of major bodily function, including a citation of the labor code as well as the abortions ban exception language in 165.8a, as that subsection is likely to lead to more confusion rather than clarity. Further, it's very concerning to see a requirement for physicians to comply with court opinions included in the rule proposal. This unusual requirement would be an immense burden for physicians, as we stated in our comment letter, and would create further confusion. It also moves in the opposite direction from the Texas Supreme Court's statement that the Texas legislature has delegated to the medical rather than the legal profession the decision about when a woman's medical circumstances warrant this exception. We're disappointed to see this confusing court opinion requirement included in the rule proposal, while the more concrete guidance from the Cox case, which could have been helpful, was omitted. Put simply, we want the ability to use our reasonable medical judgment to apply the appropriate standard of care to save life and to allow for new life to be created. Trusting the years of training and experience our physicians is vital. We need clarity. Women's maternal health and fertility are dependent on the state getting this right so that physicians can save lives and help women have healthy pregnancies. We trained for years to make sure for women and their unborn babies to promote healthy births and a healthy start in life and as a new child and a new mother. Please help us foster these healthy outcomes with thoughtful deliberation and the provision of additional clarity, not additional confusion or administrative burden on how to protect mothers and babies in these difficult medical situations. Again, we thank the board for taking on this momentous task, and we want to be as helpful as possible as we move forward to ensure the best outcomes for women and their babies. Remember, dead mothers do not leave to live babies. Thank you.
Thank you, Doctor, for your comments. Dr. Zaffron or anyone have any clarifying questions?
Yeah, Dr. Valenti, thank you for your comments. I just wanted to, I know this question keeps on coming up again, but I'm not quite sure I understand the concern about the medical record keeping, if it's just aligned with what we would normally expect from the standpoint of documenting what you would expect to be an emergent procedure or an emergency type of situation versus the risk of some bodily harm happening. So that isn't any more than what we would expect anyone to do under a similar circumstance if it didn't include a situation that might necessitate an abortion. So what is it that we're asking for extra beyond a similar circumstance that there are concerns about?
The concern is that we don't want to have to go through some sort of checklist. So, for instance, when there's an emergency and a trauma, let's say, you proceed to the operating room as indicated, and then later you delineate why you did what you did. But we don't want to have to go through a checklist or an itemized list prior to doing that. But I agree that we want to exert a standard of care and then legally justify, or in this case, medically justify why we're doing what we're doing. But we don't want to have to go through that checklist and create a delay prior to doing what we must do.
Okay, I think that's a valid question, but is there anywhere in the proposed rules that we said that you would have to document this stuff prior to doing something? I mean, normal medical record keeping can, of course, happen after a patient is stabilized and after you've addressed all that needs to be addressed, and then you can sit back and document what was done beforehand. I don't think there's, or let me ask it this way: is there anywhere in the rules that it presumes that you must do that before you actually do something, as opposed to just documenting after the fact what you did, what your thoughts were, and so forth, just like you would with any kind of emergency procedure?
No, I think what you're saying is reasonable. The concern is it was sort of implied that that's what would have to happen before we acted. And perhaps we could clarify these rules, that we would expect physicians to act as they always do, to act in the most medically prudent and reasonably prudent way without going through any sort of delay, and then document thereafter why they did what they did, just as we would with any emergency. So I in part agree with that. It's got to be a shell. We just don't need that level of detail before we go back. We just need to be able to go do what we need to do and then document like we always would. But I think there was an implied intent there that we'd have to do it before we did anything.
Okay, that's helpful. I just want to make sure that we're not having an issue with the medical record keeping itself.
No,
I mean,
so
that's
against
there,
medical
right?
record keeping, right? I mean, we're physicians. That's part of our nature, is to medically keep records appropriately and justify what we're doing. But we just don't want to be tied to that prior to acting emergently, because sometimes, I mean, a cesarean hysterectomy can lead to 5 liters of blood loss in 3 minutes. We don't want to be documenting while we're having blood loss or a baby's dropping heart tones or whatever. So I agree with you in principle. I just don't want to have that be implied as a checklist prior to.
Okay, all right, understood.
I appreciate your question. Thank you.
Yeah, and what you brought up there is a kind of recurring concern that came through in the written comments we received. And as Dr. Zaffron was just mentioning, in no way was the board ever even contemplating that someone had to run through all of that stuff and then sit down and document it first before giving the life-saving care for the mother.
Well, thank you for that clarification. I appreciate that.
Yeah.
So perhaps what Dr. Zaffron said is that we could make it clear that we would expect normal documentation, such that anyone would document that way in any emergency for any reason. Which is, again, back to the standard of care.
Yeah, absolutely. And I just want to make that clear for all the rest of our guests here today, that if that is a concern that you have, that is we can certainly find a way to perhaps clarify that in the rule itself, but that is not a requirement that would be here. Even if the rule went forward just as is right now, nobody would think that you'd have to go through a lengthy documentation process before you could save someone's life.
Well, the TMA is very willing to work with you on that language such that it makes sense for both parties.
Okay, great. Thank you so much for your comments.
Thank you,
Appreciate
sir.
it. Okay, we did hear from Mr. Bresnan that there was a problem. I think we have him back through the phone. So, Mr. Bresnan, are you with us, and we able to hear you?
Yeah, if you did call in, in order to unmute, you'll need to press *6.
Can you hear me now?
Yes, we can.
All right, thank you so much. I appreciate it. This is Steve Bresnan. I'm speaking today for myself and Amy Bresnan. Our comments supplant our prior comments on including the necessity to eliminate the transfer provision. Overall, the comments by respected knowledgeable parties make it clear that the proposed rules are not adequate and are flawed and need work. So I'd ask myself, in this situation, what should a responsible state agency do? And I would say, don't be afraid to start with a blank slate. And I would offer 7 brief items to be put into that blank slate. The first and most important thing that medical board could do is add a presumption that reasonable medical judgment is met if the physician's judgment is informed by one or more of the following: evidence-based clinical practice guidelines and protocols published by major national medical associations, including specialists in obstetrics and gynecology, and the condition that threatens the pregnant female. Number 2, conclusions of medical committees under Chapter 161 Health and Safety Code, or a medical peer review committee under Chapter 151 Occupations Code. Number 3, peer-reviewed reports of studies published in established medical journals. And number 4, information published by state or federal governmental entities that address pregnant females' condition. On their face, these rules will apply only to a physician facing medical board administrative actions, but such a presumption may also provide a defense to criminal prosecution by establishing reasonable doubt, the single most important thing the agency could do. Second, add those elements of the exception language that are clear as a matter of law by codifying the elements construed by the Texas Supreme Court in its Cox opinion. These elements include, and have been supported by all reasonable commenters: the death of the pregnant female or impairment of her major bodily functions need not be imminent. Adverse effects of her condition need not be immediate, fully manifest, or practicably irreversible. Medical certainty is not required. Consultation or agreement with another provider is not required. Third, the proposed definition of major bodily function is well established in several legal contexts. We support that, but we would suggest adding to the definition a reference to either the urinary system or kidney functioning. Fourth, we suggest affirmatively addressing timing factors that are raised in the medical board's transfer provision and in Cox by stating that a woman may decide to have an abortion at the time the criteria of the statutory exception are met. And number 2, a physician has the authority to perform an abortion at the time the criteria of the statutory exception are met, and the woman makes that decision. Fifth, add provisions making clear the exception applies in either of 2 situations. Either of 2 situations. A condition of her pregnancy threatens the life of the pregnant female, or a condition of her pregnancy poses a serious risk of substantial impairment of a major bodily function. 6, use Section 171.105 Health and Safety Code as a model to create expert panels to respond to physician requests for determinations regarding reasonable medical judgment in a specific case, and those determinations would establish reasonable doubt in the face of a potential criminal prosecution. 7th, get interested parties in a room to start drafting specific language that will work. We have proposed language for several of the items of the above, and we would appreciate the ability to participate. I thank you for the opportunity to comment today. I'll be happy to answer any questions.
I appreciate your input. Very detailed, and that's good for us. Um, I do have a question for you. One of your suggestions was, looking, a presumption of reasonable medical judgment could be established, 4 different ways. I'm just curious your thoughts on, what if, 2 or more of the sources or guides that you were referencing conflict with each other?
Well, in that case, if I'm the physician who's under the gun, I'm going to pick the one that I relied on because I have independent professional judgment. If that gives me a sound basis, then I can rely on that. It's a presumption, though. A presumption can be overcome. It just shifts and heightens the burden to the party complaining. So I realize that can happen, but that's the landscape that physicians are facing out there. And at some point, somebody has to make a judgment. The Texas Supreme Court said physicians should make that judgment.
Okay. So just to clarify, if 3 of the 4 say to do it one way and 1 of the 4 say to do it another way, if they pick the one that's the outlier, that still would establish the presumption, at least at that point in time.
If I were the medical board, I believe the person could reasonably rely on that, assuming it meets the criteria. Now, we've not drafted this part, but we would need to establish criteria in the rule that make that outlier, so to speak, something that's credible and could be relied on. On the other hand, if the medical board said 3 out of the 4 are contrary, then the medical board should put on its evidence and y'all have at it. Be up to the defendant in that case to make their case and the agency to overcome the presumption.
Thank you. Appreciate it.
By the way,
Dr. Zaflin, go ahead.
We use presumptions in the law all the time, gentlemen, and you all know that. We use it. It's used all over the place, and so this is not a novel suggestion.
All right, yes, Dr. Zaflin.
Thanks, Brent. Yeah, and again, this is kind of highlighting some of the questions that I think keep on coming up. One was the medical record keeping, and the other one that keeps on coming up is what standards that we go by, and the presumption of what is an appropriate ruling based on certain circumstances. And I just wonder, and I'm going to ask this question, is there a concern that you are actually pigeonholing a physician into a very specific set of criteria that may not necessarily apply on a given circumstance that may be going on? And again, I think I gave the example during the board meeting, a rural setting versus being in the middle of the medical center, where the exact 2 scenarios, as far as a patient's physical status, may be the same, but the correct presumption by the physician may be very different based on what the capabilities are in the given area that they're at. And again, that's why we kind of put based on what the standard of care is, and the standard of care is based on the community standard in a given area and an expert panelist looking at it from that standpoint and so forth. So do you not feel that we've given a certain amount of flexibility in the way the rule has been written versus what you're proposing, which would be very prescriptive? Because again, remember that this is looking at things prospectively, as opposed to in a hearing what we're doing right now, where you're looking at things retrospectively. So I'm just wanting to make sure that we're not pigeonholing physician judgment by being overly prescriptive and trying to define all different types of circumstances that may be very different based on the setting that they're in.
Well, I don't think the rule as I've proposed it would be overly prescriptive, since it doesn't refer to any particular condition, any particular treatment, any particular locality in the state. It doesn't say anything about anything prescriptive, but it seems to me completely normal. It certainly would be in the tort context, for example. You would have the same kinds of materials that we're talking about brought into evidence. You'd have experts that would come in and also speak to, based on given studies. This is not novel, and it has the elasticity to be able to be usable in a number of trial contexts. There may, in fact,
Yeah, Mr.
not
President.
be.
So just before you keep on going. So, and again, I just want to be careful because as we're moving forward, I just want to, you're almost talking about this as if we're going through a trial and looking at evidence. And I'm talking about a physician at a moment of time having to make a judgment and a decision on a moment's basis about what to do. And as Dr. Valenti said earlier, these are emergent type of settings where you're having to make a judgment call about what you think is your best judgment and your best call at the same time. And what we're saying is you have the ability to be flexible based on what you think your best medical judgment is, so long as you document it appropriately based on the parameters that we described. I just worry that we're kind of getting so much into what a trial would look like and as if there are stipulations of evidence and all that kind of stuff, as opposed to a moment of time. And Brent, you can kind of help me here, just, define based on a moment of time as to me making an immediate judgment as to what I need to do moving forward, not a trial looking retrospectively as to what I did being right or wrong. Brent, am I wrong there, or am I missing something?
Well, no, I think, yeah, I mean, the way the rules were written and where we were going with this was trying to give physicians flexibility to make decisions, but just documenting why they made the decision that they made. When you, Mr. President, when you talk about looking at, and that's why I was kind of asking the questions about potentially conflicting source material, we go through that now. I mean, when we have an ISC or when we do get to SOA, people will put forward and say, well, I relied on this study or this medical journal or this information, and we may not have known that that's what they were looking at. We may have looked at something different that's, like you said, contradictory to that. But those are things that already come up and are heavily influential in the cases that we have. So I just wanted to make sure when you were talking about it that it wasn't going to be necessarily something that was like, well, you relied on something, so that kind of makes it so. And so again, I appreciate your clarification on that. And as Dr. Zaffron saying, we do want to give physicians flexibility to use their reasonable medical judgment. But it's just, okay, now that you did what you felt you needed to do at that time, can you document all this information so that in the event that we do get a complaint, that's the kind of stuff that we're going to be asking for and our experts are going to be asking for anyways.
Yes, sir. With respect,
Yeah.
you are focusing on something where the woman's within an inch of dying. And this is a fundamental problem with your rules. The Texas Supreme Court has held definitively, it is the law, that immediacy of her death or impairment of her bodily functions is not required. And so if you're writing rules with respect to the gentleman, the president of TMA, your comments about an immediate emergency in the emergency room are off point and unnecessarily restrict the ability of a physician to make judgments and are completely contrary to the decision of the Texas Supreme Court, which is why one of our proposals is to include the holdings of the Supreme Court that construe the emergency, the so-called emergency exception statute. That's why we've done this. Not all cases will be within an inch of death. If you'll recall, Ms. Cox had the time to go to court. In the Zorowski case, people had the time to go to court first. They weren't within an inch of dying. And so they were looking for guidance at a time when the physician had a time to make a judgment and there was time enough to go to court. So I think the most fundamental mistake you're making is not including those elements from the Cox decision that are definitively the law in the state of Texas and easily discernible from the per curiam opinion, which means it was unanimous. So, gentlemen, You say I'm focusing on a trial, you're damn right I'm focusing on a trial. I'm a lawyer. Any good lawyer writing these rules that might be called upon to defend someone would work backwards from the trial to the kinds of information that a physician needs to be able to rely on in order to make a credible decision. It may be a different decision than someone else would have made, including some other treatise. But they have to be able, this law must work backwards from the complaint in order to be of any utility to physicians. And to be honest about it, Mr. Carlton, before I say something I don't want to, I want to remind myself to thank you to your service to the country during the middle of this complicated process.
Well, no, I appreciate that. And again, you bring up good points. Again, it's hard to restate everything that's in a court opinion or anything back into a rule. We're trying not to necessarily do that, but that is why we do have the reference of being in compliance with court opinions. I mean, that's kind of a nod of what we were kind of making there. Again, without having to just restate everything. Obviously, any rule that the medical board makes, it can't it's not superior to a Supreme Court ruling. I mean, we can't undo whatever law the Supreme Court comes up with. So again, what we were really looking at was if you feel that you need to make a decision, here's the documentation that we're going to look for in that instance. And again, I understand your point about kind of the timeline and the immediacy of making that decision. And again, we weren't really trying to get so much into, okay, this person is about to die right now. And we're trying to get more of like, well, it's a medical emergency. This is kind of how it's defined. There are some court opinions on there. And again, we're at step one of going through this process, and we appreciate your feedback. And again, I want to make it just kind of say like our thought was not that someone has to be on death's door to do something.
Yeah, Brent, just to highlight the fact that part of what we talked about also is preventing permanent organ damage as being one of the criteria. And certainly, in the prevention of organ damage, people can have potentially permanent organ damage and not be at death's door. And certainly a physician feeling that not intervening could potentially cause permanent bodily harm is something that we have identified as an exception. And I mean, there may be some ways that we can make this more specific, but I really don't think that there was any attempt to intimate that immediacy was needed from the standpoint of being able to act on it. I believe that if a physician understands that not intervening is going to lead somebody to become septic a couple of days later, and that their judgment is that they would need to intervene right now to prevent a patient from potentially becoming septic, that would be something reasonable for them to do. That would be within the standard of care. I don't think that there's any intimation that you have to wait until the patient became septic and potentially at death's door before they would need to act or intervene. So again, I just want to make sure that for everybody here that's listening, that is certainly not the intent of the board. And if there's something that we said in the proposed rules that intimate that, then again, we're happy to take suggestions along those lines. But that's certainly nothing that we intended.
It's what was not said, Doctor. The point here is to have the state, through your action, tell physicians exactly what you just said. That's the point. And if you fail to do that, you're not achieving anything. By the way, one of my suggestions here, I mean, I've made this multiple times, is you make it clear that there is an or. It's either or it was life-threatening or threatened major bodily functions. The statute, unfortunately, is a terrible sentence. And through the board's interpretive authority, through the Administrative Procedures Act, you can make that absolutely clear to physicians it can be life-threatening, or it can threaten substantial impairment of her major bodily functions. That's a problem of statutory construction, interpretation. You have the legal authority to make, and if you'll carefully study the statute, you'll see that that's not clear. So physicians and their lawyers would know that there are two separate, distinct considerations. We wrote about this in depth at our original comments.
Okay, we appreciate the feedback, and this is good out of the first two speakers to go ahead and get that out and clarify. Again, the board is not looking for physicians to do all this documentation before acting, and the board is not looking for the patient to be at death's door, so to speak, before being able to act. And we can certainly look at ways to make that clearer.
Okay, thank you for the time you've given me. I sent you Amy Bresnan's phone number because I think she had to rely on her phone number too.
Okay.
512-507-7602.
I see it. Okay. I see it there.
Thank you all.
All right. Thank you.
Bye-bye.
Yeah. Thank you. Yep.
You bet.
All right. And with that segue, we will go to Amy Bresnan.
Well, that was pretty hard to follow, and I did promise the chairman that I would give him some time back, which I intend to do. So let me get to the point. The transfer provision is frankly just flat out scary. I want to read this so the public understands exactly what it says. Whether there was adequate time to transfer the patient by any means available to a facility or physician with a higher level of expertise to avoid performing an abortion. First of all, the problem with this is that based on the timing, a physician had probably already concluded that an abortion under the circumstances satisfies the statutory exception. There's also no requirement that the patient give informed consent to transfer. And based on some of the stakeholders' writings, which are discussed in our comments on pages 3 through 7, it looks like we can figure out what the result will be, and that is delaying care for women experiencing life-threatening complications in order to perform a C-section or induced labor, even when there is no chance that the baby will survive outside the mother's womb. And I want to make it very clear, I am a C-section baby. I don't have anything against C-sections. I would not be able to call in and speak to y'all today if it hadn't been for a C-section, which I realize may make some happier than others. But anyway, so performing a C-section for the purpose of delivering a non-viable or pre-viable fetus could be an unjustifiable dismemberment of the mother unless that is her choice. And we do know that some people will choose that. But we also know that 95% of second trimester pregnancies are terminated by D&E, despite C-sections and induction of labor both being widely available throughout history. Also, we're concerned about the cost of the alternatives to abortion, which we imagine would be in place here. C-sections, the average cost is $26,000 without insurance. The average cost of induction of labor is $14,000 without insurance, and even with insurance, both of these are very, very expensive. And we also assume that by any means available that you are considering air ambulance flights. The median cost of an air ambulance trip is $36,000. So in conclusion, please remove this provision altogether, as it will cause more delay, more harm, and could possibly even bankrupt Texas families who are trying to have children. Thank you for your time.
So, Mr. Carlton, if I could just ask a couple of questions.
Yeah.
If I could just ask a couple of questions. I want to just, highlight two different scenarios. Let's say that the patient is over at the Texas Medical Center and, there are concerns that she has an infection for that patient to be treated appropriately, she would probably need to be transferred to the intensive care unit. And in the intensive care unit, they would put her on antibiotics, hydrate her, do all these things. And the cost of that would be substantial, potentially. whether they have insurance or they don't have insurance. And I wonder, in a scenario like that, could a patient decide not to go to the intensive care unit because of the concern for cost, and decide to do something different, even though that option for saving that person's life is something that is completely, appropriate and would be the standard of care. And then the second question is, if that person is also in an urban area, in a rural area, and the patient presents themselves and there isn't really good intensive care there, there isn't the ability to, resuscitate a patient, and a physician sees that patient, they're still relatively stable, but there's high concern that they could become septic. And if there's not a reasonable ability to transfer the patient, then that would lead down one path. Patient may need to go ahead and have an abortion right there and then to save her life. But if there is the ability to transfer and the patient is completely stable, not at the point where there's any harm to that person, but there could be if there's delay, but there's the ability to transfer to a higher level of care where they can get to that intensive care unit, get into being treated prior to becoming septic and then being completely fine. Again, I'm trying to give different scenarios and the flexibility that physicians would look at facing cost being a factor in both scenarios, but I don't think that we would say, no, don't transfer the patient from the floor to the intensive care unit at one hospital because of cost, versus in a rural area where there may or may not be the ability to transfer. And with that, there may be two different decisions to be made. The physician says, I can't transfer, patient's going to become septic, I need to go ahead and do an abortion. That's fine. There is an ability to transfer. I can get that patient to an area where they can get treated and prevent them from getting septic potentially, and that would be an appropriate judgment. So where is what we're saying the rule not giving that flexibility to allow for all those different scenarios?
Well, first, I think that all of this could be subsumed into 6. I think 7 is possibly. I think it's repetitive and unnecessary because of the record keeping requirements in provision 6. And secondly, I want to make sure that I'm being clear upon the diagnosis. So when the woman learns that if she goes through with this pregnancy, she's either going to die or she's going to lose a major bodily function, including fertility. Upon diagnosis, that woman should be afforded the option of a D&E or an abortion, rather than having to be transferred for the purpose of delay. So I want to make sure that everyone understands that this is absolutely a timing issue. And what we're saying is that upon the woman hearing her diagnosis, that she should be able to make that choice as to whether or not to be transferred. That's really the situation that I'm talking about. A woman learns.
Yeah. So I guess I'm asking specifically though, if the diagnosis is based on the fact that if they got transferred, then the diagnosis would be that she would have a complete recovery potentially. Then again, I'm worried that we're kind of pigeonholing ourselves into a very, very narrow area where the diagnosis could be different based on the circumstance. If I'm able to transfer the patient, my diagnosis is that this person would recover. If I cannot transfer the patient, my diagnosis is that this person will become septic and I need to go ahead and intervene immediately. So those are still two very different scenarios. There's no final diagnosis made, but I'm saying that the diagnosis is going to be based on what I'm able to do. Can I transfer? Can I not transfer?
So in this situation, I mean, because statutorily speaking, and the statute does still give the woman more deference than the fetus, in this situation, what would you have done in the year 2019? I guess, I mean, because we are at the point where a woman under statute is afforded the right to an abortion. So my question would be, what were y'all doing in 2019?
Well, we weren't getting complaints.
Mr. Carlton's question.
Yeah. So we weren't getting complaints on this in 2019. So it's hard to say like what exactly the board was doing about it then. This wasn't an issue that really came up. But in trying to go through the rules, as Dr. Zafran said, and again, that's what we're trying to get at here is it's not an attempt to delay care for someone. It's more of just documenting, was there another option available? Yes or no. And we decided not to go with that option because of this reason. And that's what's put in there. Again, as Dr. Zaffron said, the situation may be different depending on the diagnosis and the care that's available at the time. So in one setting, if we don't transfer, the only option available is to perform an abortion to save the mother's life. However, if we did transfer, we wouldn't have to do that. And both may survive. And so that's kind of what we're getting at with this rule, is the documentation of, what was there another option essentially available where a different path could have been taken, and there may not be, and there may have been, but you couldn't take it for various reasons.
And I do think that all of this could fall under provision 6, which would make 7 unnecessary. And I see your point, but I think that this provision as a standalone for sure is scaring a lot of women. And then,
Okay.
I mean, at the very least, she should have to consent to a transfer.
Well, again, patients have to consent to anything that's done to them. I mean, we're certainly not saying the physician has to,
unless they can't, right? I mean, unless they're too sick to consent, which, as y'all know, as doctors, that happens a lot.
Well, yes. I mean, if someone's incapacitated and you don't have anyone there that has a medical power of attorney or that's able to make decisions on their behalf, I mean, what we do have now is physicians will make decisions for them in those situations. That would probably be what is happening here. If someone was so incapacitated and there was nobody else around to speak on their behalf, we would do what happens now. Physicians make decisions. You have other physicians that kind of review that, sign off on it to make sure they're doing what's in the best interest of the patient. But again, it doesn't say anywhere in the rule that, even if the patient is against being transferred to another hospital, you have to, put them in an ambulance and take them against their will to go somewhere else.
Mm-hmm. Well, y'all are clearly you're taking our suggestions very seriously. We know this is a lot, and once again we appreciate all of the thought and consideration that you're putting into this. It has not gone unnoticed, and we know it's difficult.
Absolutely, and again, we're certainly not trying to be argumentative. I think we're trying to clarify kind of where we were coming from with the rules,
Sure.
also, so that there's not a misperception of, well, the board did it for this reason when really maybe did it for an opposite reason. But I mean, that's understandable. You're just reading something that's written out, and you can have interpretations of what it means and what was behind it. So we really appreciate the dialogue back and forth.
Yeah, and we do too. We think of arguing as just having a conversation. So we're all good. Thanks, y'all.
And Ms. Bresnan, by the way, we are taking what you're saying to heart, because it is important for us to explain to everybody and to you also what our intent is. And we may look at it and say, we think we've explained it well enough, or we may say, what, some of your suggestions would help clarify what our intent is even better. And that is part of what we want to be able to look at. So this conversation is helpful. It's not intended to be defensive in nature. It's intended to be more of, this is what our intent is. You're making points, I think, that are very valid, and we want to be able to look at those suggestions and see where they may be able to, further help explain and clarify what we're trying to do.
Well, we like I said, it's clear that y'all are working and thinking about it, and we're here to help. Thank you so much.
Thank you. I appreciate it. Okay, next, Ingrid Scott.
Good morning. I'm
Morning.
Ingrid Skopp, a board certified obstetrician gynecologist practicing in San Antonio for over 30 years. Thank you again for the opportunity to provide input into your proposed guidance. As discussed, Texas laws do not require the risk to a mother's life to be immediate, only foreseeable. At the time of diagnosis of a potentially life-threatening pregnancy complication, a physician must be reassured that the law allows him to use his reasonable medical judgment to determine whether and when to intervene. Most often, this maternal fetal separation is performed by labor induction, although the laws do allow abortion if indicated. Relying on ACOG or other professional practice guidance can help doctors make and document their decisions. For example, ACOG's practice bulletin on pre-viable premature rupture of membranes states immediate intervention by induction or abortion or expectant management in the absence of infection are all options that should be offered a patient, and Texas law allows these interventions at diagnosis. In the event of a rare complication not addressed by the professional literature, a multidisciplinary hospital quality committee can meet urgently to provide guidance. There is no excuse for a doctor to wait until a woman is dying before he is willing to intervene, as we have seen happen. Some today have mentioned confusion about documentation when these heartbreaking decisions are made. The board should use its professional authority to encourage hospitals to also provide clarification and support for their physicians by updating and distributing therapeutic abortion protocols so that physicians are aware of the requirements for decision-making and documentation within their hospital systems. The irrational fear of physicians leading to failures of timely interventions for Texas women is unnecessary. The board needs to reassure physicians that there has never been a doctor prosecuted in Texas for performing an abortion to save the life of the mother. As an example of the erroneous advice that physicians have been given, ACOG's journal recently published an article that blatantly misrepresented Texas laws, stating that Texas defines life-threatening as an imminent risk of death and that the maternal health exception poses a problem for practicing physicians in that it is often unclear how close to death or harm a pregnant patient must be before abortion is legally justified. The author also claimed that pregnant patients in Texas must wait for their condition to deteriorate substantially before they can legally receive a medically indicated abortion. This is demonstrably false. In 2023, the Texas Supreme Court held that the Texas abortion limit does not require imminence or that a patient be about to die before a doctor can rely on the life exception. I wrote a response to this egregious misinformation, and it was published in a peer-reviewed journal last week. I've attached that article to my written testimony today. Finally, I'd like to conclude by relaying a personal story of how doctors continue to harm women due to misunderstanding of the laws. Last Monday, I cared for a woman in the emergency room who presented hemorrhaging from a miscarriage. Her pregnancy loss had been diagnosed 2 weeks earlier by her physician at 10 weeks gestation, but he told her that Texas law required another ultrasound before he could intervene. This is untrue. Since we can detect cardiac motion at 6 weeks gestation, the failure to detect a heartbeat at 10 weeks gestation is definitive evidence of fetal demise. He could have intervened and spared the woman the emotionally and physically traumatic experience that she had in my emergency room. Stories like this abound in Texas, not because of the laws, but because of failure of hospitals and medical industry organizations to provide guidance to physicians. Texas women are often not receiving quality care due to physician fear and misunderstanding of the laws, and I eagerly anticipate the board's guidance. Thank you.
Thank you so much. I appreciate your comments. As you said, as we've talked about before, imminent death is not required. That's not something that we have in the rule. When we try to talk about what is a medical emergency, it means a life-threatening physical condition, but it doesn't have to be something that's imminent. So we appreciate it, and again, if there are ways that we can make that clear, we'll certainly look at taking that opportunity and the rest of the comments that you provided as well. Dr. Zafran, if you had anything in addition.
No, I think it's a recurring theme, and I understand, and it's something that we will try to address. And if we can address it in the rule specifically, I mean, there are obviously opportunities and ways that we can address it, possibly in FAQs afterwards too.
Yeah.
Thank you.
Thank you. Okay, next is Charlena Bohm. And I apologize if I mispronounce anyone's name today. If you're on, if you can, when you unmute yourself, everyone just go ahead and state your name. That way we do have it correctly in case I made a mistake. Charlena, are you on with us? Can you hear us? Okay, not hearing yet. We can come back like we did before. And this is also a reminder for everyone. We do have a list that we're going to go through. There are a total of 29 names on the list. Charlena is number 6. We'll go through them all. And once we get to the end of that list, if there are other people that would like to speak, you certainly will have that opportunity, but we're going to go through the list that we have here for those that signed up first. Just checking something here. Okay, we'll go next to Stephen King.
Hello, can you hear me?
Yes, we can.
Well, members and guests of the board, thank you for the opportunity to engage with you today on a subject of profound importance, the abortion laws of the state of Texas. Well, my purpose here is to advocate for expanded exceptions to these laws and to address the pressing need to protect our medical providers from undue legal risks. I may be slightly less informed than some of your other speakers are on the current provisions that you've already made. But I wanted to add that currently Texas stands with some of the most restrictive abortion regulations in the country. These laws permit abortions only when the patient's life is in danger or in cases of medical emergency, without exceptions for rape, incest, or severe genetic disabilities. This lack of exceptions doesn't account for the psychological trauma and the mental health risks imposed to those forced to carry pregnancies under such distressing conditions. The mental health implications of forcing a woman to carry a pregnancy resulting from rape or incest can include severe depression, anxiety, post-traumatic stress disorder, and even suicidal ideation. Yet our laws overlook these substantial risks. Furthermore, young girls and individuals with significant disabilities are disproportionately harmed by these restrictions, often facing grave physical and psychological consequences. However, the protection of our patients cannot be effectively addressed without also considering the position of our healthcare providers. Under the current legal framework, providers may face criminal prosecution and civil penalties for performing abortions, even when they believe it to be the best interest of the patient. Now, this not only hinders their professional judgment, but also places them in an ethically untenable position. Therefore, I propose that we advocate for laws that clearly protect medical providers from prosecution when performing abortions under the exceptions we seek to establish. Now, we have to define medical judgment to allow physicians to consider both the physical and psychological health without fear of legal repercussions. This protection is crucial to ensure that providers can offer necessary care without the threat of legal action. Moreover, by expanding exceptions and articulating clear protections for medical providers, we can ensure that Texas is a state that truly respects the health and autonomy of its residents. It's our duty to ensure that our laws reflect compassion and pragmatism, safeguarding the rights of women to make informed decisions about their bodies, enabling medical professionals to provide the best possible care. Now, as members of this esteemed board, you have the capacity to influence these changes. So let us work together to revise our policies, making Texas a leader in ethical and humane healthcare practice, not only considering the legal implications, but also the human consequences of our decisions. As I've listened today to other people's information and testimony, I'm also brought to mind to ask, have you considered suggestions in wording or verbiage for the physicians during the documentation after a procedure. I yield the rest of my time for questions or comments.
Thank you so much for your comments. And some of the things that you brought up are also some concerns that we've received in the written comments over this last almost couple months here. And to address a couple of them for you, first to answer your question, have we spoken with physicians about the wording of the documentation? We do have physicians that work on staff, and we do obviously have board members that are physicians. Dr. Zaffron is a physician. And so talking with some of them, we have kind of helped get us to where we are, at least as a first step, a first draft to put out there for the proposal of the rules. And that's really what you guys are doing today. And the written comments we've received is getting that feedback to see what kind of revisions we need to make for any documentation or anything kind of along those lines of what you're referencing. So we're going to go through that process when we complete the stakeholder meeting today and continue to receive the written comments from the public. The other piece that you brought up, again, has been suggested in the comments as well about why the board doesn't add in additional exceptions for like you said, for rape, incest, certain mental or physical disabilities that someone may have. And the reason for that is the board is not allowed to do that. The statute as written, it's what lays out what the exceptions are allowed, and they talk about this medical emergency. And so the board is we don't have the legal authority to expand that more than what the statute provides. And so that's why the board is, kind of focused in the areas where we focused on, because that's what the statute allows us to do. And so again, want to make that clear for you and for anyone else that's listening or may have comments to the similar effect. That's not something the board has the authority to do, but that is, as you said, that is something that the public and through associations and organizations could speak to the legislature and make that case of, hey, we think that these exceptions need to be added. And if something like that did happen in this upcoming session or future sessions after that, then obviously the board would respond and accordingly, and our rules would have to adapt to whatever statutory changes came with the revisions to the exceptions as written currently. But again, you bring up important points. Another piece you brought up is about specifically having something for mental health. Again, that's not something that the board is, that the law allows as a specific reason to perform an abortion. But you said there can be things where people have kind of some severe mental health issues and challenges that can arise during certain situations, but that's not something that the board or the statute allows to focus on. It's really kind of focused more on kind of the physical piece of it than the mental health piece of it. But your point is certainly well taken, and it is something that has been brought up by multiple other people. And I thank you for your comments. And we'll take the rest of what you said in addition with everyone else's and kind of keep going through that revision process.
Thank you, Dr. Carlton, for the clarification.
Oh, I'm not a doctor, but yes, thank you. I appreciate it. Now I get that. I get that a lot though. But no, I'm not a physician, but thank you.
Yes.
No. Okay.
Mr. Carlton, we do see Ms.
Yes.
Sharina Blown back in the meeting.
Okay, great. Sharlina, are you with us? And are you ready? Alicia, is she on Teams or just through phone call?
I do see her on Teams. I do see her unmuted with you.
Hello, can you hear me?
Yes,
Hello?
yes, we can. Yes, go
Hi.
ahead. Yeah, state your name and 4 minutes are yours.
If I could, my name is Raul Lopez. I represent District 11, ACOG chapter here in Texas. We have one of our doctors representing ACOG, Dr. Richard Todd Ivy at the believe he is one of the people raising his hand, might be under unknown user. If you could allow him to deliver our comments on our behalf, is that possible?
Yes, permissions
Okay.
have been granted.
Okay, go ahead.
And you don't need to unmute on your end. But your mic has been allowed.
If we could circle back around one more time.
Sure.
My apologies.
Yeah, absolutely. Yeah, no
Thank you.
problem. No problem. We can come back. Let's see. Brittany, oh man, I might with this Trinity.
It's great. I mean, like,
Okay, how about Karen Swenson? And to keep things moving, we'll just kind of go through these quickly, and we'll come back to you if we don't hear you. How about Tony Wing Jenkins?
My name is Tony Wing Jenkins, and first I'd like to thank the members of the Texas Medical Board for your efforts to clarify what a medical emergency is pertaining to the need for an emergency abortion. First of all, the board needs to not write these guidelines with the premise that only medical personnel will be reading them. The nature of the topic makes that premise a bit falsy. Thusly, I believe guidance must be further written that will protect doctors from frivolous legal and civil repercussions when they've used reasonable medical judgment, such as those listed in your proposed exceptions, and protect women from suffering the inability to carry future pregnancies and death. While you lack the authority to completely eliminate criminal or civil actions against doctors who use reasonable medical judgment and follow all procedures, providing enough clarity could protect doctors from nuisance prosecutions and lawsuits, thus protecting women from undue delays in treatment and victimization. First of all, emergency treatment does need to be clearly defined as such that the woman is not in danger of imminent death. I know it's implied, but I think it needs to be stated clearly. Next, the guidelines need to be very clear that the decision is between the woman and her physician. The priority of the well-being of the woman needs to be clearly stated. While it may seem at first reading that it is, a statement saying that the well-being of the mother is paramount and the decision to take action is one made between the woman and her doctor, I think it needs to be stated between 165.8a and 165.8b. Following the premise that the woman is paramount, the guidance in 169.8b7 needs to be restated so that transportation will not place an undue trauma on the woman, or the transportation requirement be eliminated completely, with the assumption that it would be a part of standard care and does not need to be stated. I repeat, it is critical that these guidelines be written to protect the total welfare of the woman, and the decisions regarding the conduct of physicians in the termination of pregnancies must remain between the patient and the doctor. They should also be written to protect physicians from unreasonable fears that their decisions will face criminal and/or civil liabilities. As a result, Section 165.9 should be written in such a way that the process of challenges or complaints regarding physician decisions to terminate pregnancies be filed first with the Texas Medical Board. Barring that, the board should be called upon to investigate and make a medical ruling on any and all situations in which there are legal or civil challenges outside those made by the patient herself to physician decisions. It needs to be clear that these decisions are medically based, not that based upon political maneuvering. Finally, carrying a non-viable fetus needs to be attended to in this document. The act of being forced to do so places an undue physical, mental, and emotional distress on the mother. Fetal anomalies or abnormalities may pose a risk to the mother's health and affect the viability of future fetuses, and it should be addressed here as well. Thank you.
Thank you. Appreciate your comments. As I hear what you're saying, as far as, that it, at least unless I misunderstood, that, any kind of challenges to the abortion that was performed itself needs to go through the medical board first for some type of determination. Unfortunately, again, that's not something that we can dictate, that a criminal or civil prosecution has to wait on something, that a determination that we make first. But I do hear what you're saying, and that is something where you can have 3 different processes playing out simultaneously, all stemming from one medical procedure. But the board does not have the authority to require the other 2 processes to wait and kind of go off our determination. The reality is that whatever decision we make, that may influence a prosecutor and a jury, and it may not. But that's just kind of the way things are at this point in time. But I do hear what you're saying, and I do appreciate your comments.
Thank you.
Yes.
And yeah, Brent, if I could just answer also, just similar to what you said. I mean, that is something that actually applies to any part of the Medical Practice Act. There have been instances where physicians have been accused by prosecutors of misusing or misprescribing opioids. This is something that typically would come as a complaint to the medical board, but a prosecutor may decide to press on their own charges and proceed on that way. And we have no control over that. Now, there are many instances where, prosecutors would defer to the medical board, but they don't have to. And again, we have no control over that. So just like anything else with the Medical Practice Act, it can take on many different forms, whether it's coming from a prosecutor in a given county, whether there may be civil action, or whether it comes as a complaint to the medical board. All we have control over is complaints that come directly to the medical board. Now, again, the Supreme Court said that it would be of value for the medical board to give guidance. And, again, prosecutors and attorneys around the state can take that for what it's worth. I'm a little biased, but I think there is value on things coming through the medical board first. But as Mr. Freshour and Mr. Carlton can highlight, that is certainly not a requirement, and it's not something that we can directly control.
I appreciate that. It's just, of all the topics, this is more likely to be used for posturing and maneuvering. And so that's the sadness of it, that someone's well-being becomes a political volleyball. But thank you very much for your efforts.
Yes, thank you. Thank you. We'll go one more, and then we'll circle back to Charlena and their group. Let's go next to Molly Duane.
Good morning, everyone.
Good morning.
My name is Molly Duane, and I'm the lead attorney in the ongoing court cases on behalf of multiple Texas OBGYNs, as well as Amanda Zarowski, Kate Cox, and many others seeking clarity regarding the medical exception to Texas's abortion bans. Our legal team is composed of attorneys from the Center for Reproductive Rights, Morrison & Foerster, and the Kaplan Law Firm, and we are currently awaiting a decision from the Texas Supreme Court in one of those lawsuits. While our team appreciates the board's intent in writing these rules, as discussed in our written comments that we submitted on behalf of our clients, we as their legal team believe that the board's proposal will only add further confusion to the situation that is unfolding in Texas, and for those reasons, we oppose the rules as written. Fundamentally, the proposed rules have misinterpreted the true purpose of any guidance for medical professionals in this area of the law. Namely, that first, physicians need guidance on when they can provide abortions, not more reasons why they shouldn't. Second, physicians need to know when their medical judgment will be considered presumptively reasonable. Not more reasons for this board, prosecutors, or anyone else to second guess their judgment. especially when, as folks have discussed today, there are such severe professional and criminal stakes. A recitation of some, but not all, of the pre-existing definitions under Texas law, unfortunately, does not serve these goals. The new proposed documentation requirements are particularly counterproductive, and the board's continued silence on the vital areas of confusion, including what makes medical judgment reasonable and how close to death a patient needs to be, also does not serve the board's goals. As to the documentation requirements, they introduce additional barriers to reliance on the medical exception, and in so doing, exceed this board's statutory rulemaking authority and directly conflict with existing statutory requirements under Senate Bill 8. And so I strongly urge the board to abandon those unlawful actions. Even if the board were authorized to adopt these new requirements, the proposed rules create an additional punch list of criteria that a doctor must assess before they can move ahead with abortion care with any level of confidence. And I have to say that this is true regardless of when, before or after an abortion, a doctor performs the necessary paperwork. I want to respond to some of the comments that have been made so far this morning and emphasize that many of these documentation requirements are not normal documentation. They go far beyond what normal documentation requires and require physicians to document certain nonsensical things that were considered and done before an abortion was performed. As a lawyer who's represented Texas physicians for years, I wouldn't even know how to advise a physician client on how to comply with some of these requirements. In particular, when an abortion is the medical treatment necessary to save a patient's life or fertility, there are no alternative treatments or procedures to try. As folks have discussed this morning, the requirement to determine when there was an adequate time to transfer the patient by any means available is so vague as to be unworkable. Now, in the ongoing litigation in Zarowski versus Texas and Cox versus Texas, our clients contend that denying abortions to patients with severe obstetrical complications is a violation of their rights under the Texas Constitution. The board may believe that our clients were not eligible for abortions under the current legal scheme, and that it is outside of their powers as an agency to write new rules concerning those exceptions. But your ability to take positions in our lawsuits as a defendant in those suits is not so limited. So to the extent that the board nonetheless believes it was cruel or unsafe to deny our clients abortions, I invite the board to take that position during its ongoing litigation and agree with us. Thank you for the opportunity to speak with you this morning.
Thank you. Appreciate your comments and thoughts that you've shared with us. Obviously, the board is not going to make any comments about the litigation during this setting. But I do have a question, and it has come up from some of the other speakers, and we'll probably hear some of it some more. But just out of curiosity, when you're saying that the way the rules are written now, it makes things more confusing, more onerous, which is not our intent. But if that is the way it is, would you prefer that there be no additional rules at all versus the way it's written now?
I think that the board has an important role in providing clarification of the rules as long as that is within its rulemaking authority under the Texas APA. So I think that the first part of the rules, which attempt to catalog all of the definitions and applicable rules and court opinions, could be very helpful if you added in, for example, as other folks have discussed this morning, that the Texas Supreme Court said that the risk to the patient's health does not need to be imminent. Another example, as I believe some other folks have discussed this morning, would be to clarify that the confusion within the way the statute was written notwithstanding, it is both an exception to the abortion bans to provide an abortion when there is a risk of death that or is very key, there's a serious risk of substantial impairment of a major bodily function. So in our written our written comments to the rules, we suggest that the board take all of the rules as they exist, be they in regulation, in statute, or in court opinions, and compile them all into one document so that physicians only have one place to go to see all of the relevant rules that should guide their decision making. But I think where the confusion comes in is that the way the documentation requirements in particular are written, it's exactly opposite from how it should be. It should be that as long as a physician documents X, Y, and Z, an abortion is okay, and the doctor's judgment is presumptively reasonable. Instead, as I read it, the documentation requirements say it is only okay to provide an abortion if you document, and then ticks through a number of things, which to my eyes are some of them may be okay. I think the first 4 perhaps are all right, but 5 through 7, I think are very confusing and will inevitably chill physicians' reliance on the medical exception. And that is what my clients have told me. That is what you've heard from the Texas Medical Association this morning. I believe that's what you're going to hear from Texas ACOG and other major medical organizations across the country who have read these documentation requirements with extreme alarm. So I would strongly urge the board to abandon at least those 5 through 7 criteria, as that's only going to create further confusion for physicians.
I appreciate your answer. Thank you.
Thank you.
Any other questions for Ms. Duane? Okay, thank you so much. We appreciate your time.
Thank you.
Okay, we'll go back to Charlena with, I think it was Mr. Lopez who spoke up.
Yes, Mr. Carlson, we have Dr. Ivy dialed in, ending in 55. I believe he has his hand raised.
Okay, and the number ending in 2655?
Correct. Yeah, I believe he's unmuted himself.
Okay,
Hello,
well,
can you hear me?
yep, yes, we can. Glad to have
thank you very much.
You have 4 minutes, and you may begin.
Thank you for this time. I'm Dr. Richard Todd Ivy, a practicing board-certified obstetrician gynecologist in Houston for over 25 years. I'm here on behalf of the American College of Obstetricians and Gynecologists and the 3,200 plus practicing OBGYNs in the state of Texas. Current law around legal abortion in Texas is incredibly complicated. Our physicians are not alone in thinking this. Attorneys, hospital administrators, and patients are every bit as confused when faced with interpreting state law. We are all currently finding it very difficult to protect the health of our patients. We commend you for attempting to address this confusion and have this conversation. Unfortunately, the proposed rules do nothing to clarify or protect physicians who may find themselves under the threat of imprisonment, loss of their medical license, or huge financial penalties for attempting to make the best decision for their patients in an emergency situation. Unfortunately, the increased requirements for documentation are truly unworkable. The need for literature searches, attempts to transfer patients by any means available, documentation of how we determined a woman's danger of death or serious risk, the need for consultations, opinions of medical ethics committees, attempts at alternative treatments, and determination of a woman's risk to support a particular method of termination. These are all incredibly cumbersome and time-consuming. These documentation requirements also do not honor a patient's wishes. These requirements, if enacted, will worsen the problem and lead to additional unintended adverse consequences for patients. And regarding the determination of reasonable medical judgment, remember, reasonable medical judgment should not be held to a standard of medical certainty. Providers consulted for second opinions or medical ethics committees may not agree on a single plan of action. Reasonable medical judgment is not limited to considering only adverse events that will happen without an abortion. As such, it should not require waiting until the mother is in imminent danger of death or impairment. Treatment should not have to wait for consultation with other physicians who may not be available, or for results of diagnostic imaging and additional tests to be completed. In the Kate Cox case, we saw that a physician's reasonable medical judgment was not recognized by the court. Ms. Cox's medical options were eventually determined by persons who lacked the knowledge, experience, and expertise to do so. That should concern each member of our board. These decisions should be made by a patient in consultation with their physicians, because that is the practice of medicine. In conclusion, the decision for a patient to have or a physician to perform an abortion is a very complex one. Every situation is different, and current state law has limits on when that can be done. We as physicians want to work within the confines of the law. but we cannot do so if our hands are tied. As physicians, we believe our patients need unimpeded access to the full spectrum of reproductive health care options. We want to make the very best decision for the health of our patients during their pregnancy, and we know that you want that too. But until the severe criminal and civil penalties are removed from state law, this climate of fear within our medical profession will persist, and the women of Texas will remain at the mercy of non-medical professionals. We urge the Texas Medical Board to advocate for patients and physicians. We welcome the opportunity to continue working with you in doing this. I'm available to answer any questions you may have, and I really appreciate the time in allowing me to speak. Thank you.
Mr.
Thank you,
Colton, let
Doctor.
me just want to ask a
Sure.
couple of questions here. So, first of all, let me just start off by saying we have no control over the civil and the criminal side of things whatsoever. I know that keeps on getting brought up, but I just want to emphasize that that is not something within the authority of the medical board to affect one way or the other. All we have authority over are complaints that would directly come to the medical board and to our agency. And I know Mr. Carlton and Mr. Freshar can emphasize that. But let me just come, because this keeps on coming up as a theme. Let's just take the fact that if there's something that is imminent that is going to happen, that there's a lot of clarity that a physician will be given a lot of latitude in determining that imminence and that something has to be done immediately. I think that's relatively clear. Let's now take an incident or a situation where imminence is not an issue. Obviously, that means that there's a little bit more time to make a methodical judgment as to what should be done. And let me clarify here that this is not just like any other typical medical procedure. We're talking about termination of a life here and whether it is okay to do that. So let me kind of give you a different scenario here. If you have a patient where you're trying to determine that that brain death might have occurred and whether withdrawal of treatment is necessary, I think that we would all presume that looking at medical ethics committees at a hospital or consultation with another physician or other possible modes of treatment are something that would be completely appropriate. Again, presuming that there is enough time to kind of go through the process of making sure that before one is going to make that decision to terminate a life because there is potential bodily permanent injury or potential death if you're going to wait. And again, I'm not saying that we're waiting until imminence is there. I'm talking about a situation where imminence is not there, but a determination of whether waiting would lead to that. So again, I'm having a little bit of a hard time understanding where the concern about additional medical documentation or concerns for additional testing or other options. In other instances where termination of life is a potential thing out there, are we not already doing these things in determining whether something is appropriate to be done or not when a life specifically is concerned? Again, whether it's terminating a life potentially because we're presuming that they are that brain function has ceased to exist, or whether prolongation of one life may harm. Again, I'm just trying to wonder where is this concern about additional criteria when we're talking about specifically something here that is a termination of a life and imminence is not an issue, and whether we're making the right decision or not.
I do think that second opinions are appropriate in some cases, but they're not necessarily appropriate in all cases. Now, in the situation where imminence is not a problem, then yes, it may be. But if I'm in an emergency room and I have a patient that comes in and she is 11 weeks and she is actively hemorrhaging, all right, and we do an ultrasound, we have a pregnancy test that's positive, we do an ultrasound and see fetal heart activity, fetal cardiac activity, she still, if her cervix is open, it's still considered inevitable. And there are many places that will look at this law and say you're not allowed to act until the mother really starts having a significant problem. And many people will say, how low does her hemoglobin have to be? How much blood does she have to lose before we can safely make this decision. So yes, there are absolutely times when second opinions and other consultations may be appropriate, but there are times that it may not be. And I think what I really, and what we would like the board to do, even though you can't change law, I think we would like for you to advocate for us, to help us understand that when we're out there fighting to protect a woman's life, that we're not going to be subject to criminal and civil liability.
So I hear you, and if I'm not a board member, I would probably be saying the same thing. But that's why there's the Texas Medical Association and ACOG and other agencies, because I'm sure, as you're aware, the medical board as a state agency can't advocate for a position one way or the other. But kind of going back to what you just said a second ago, if you have somebody in the emergency room who's actively hemorrhaging, I'm not quite sure that there's anything in the rules as it's written right now that would prevent a physician from making that judgment that something would need to be done immediately. And the record keeping that would be involved in doing that, which would be important regardless whether we have this rule or not, I think that's something that all of us as physicians would understand, is easily something that would be done after the fact, after the patient is stabilized, after the intervention to make sure that the patient is stabilized. And hemorrhaging, to me, is something actually I would look at as an imminence thing. If somebody's actively hemorrhaging, I'm not going to wait until the hemoglobin is 4 before I act on it, especially if they're actively hemorrhaging. But I would expect that after the intervention is made, that you're going to sit down and document that I saw this patient in the emergency room. The patient was actively hemorrhaging. I felt that not intervening would put the patient at risk. And this is my judgment as far as proceeding. And I believe the way we have the rule written right now, that would be completely okay. Of course, a medical expert or a medical panelist, an expert panelist in your specialty would be reviewing a case like that if it came to the board as a complaint. And my presumption would be that that specialist or that expert panelist, being an OBGYN in a given scenario, in a given situation, would probably make the same presumption. So nothing is different there. And that's, I just want to, the reason I'm taking a bit of time to talk about this is I just want to make sure that if there are things that we can do to highlight that imminence is not a criteria, but when imminence is there, that we're following what we would normally do today anyway, the rule already highlights that. But again, we can't do anything to prevent civil or criminal action from a different entity. But from within us, we would ask you to do what you would normally do in a given scenario today, presuming that you have a patient in the emergency room that needs immediate intervention. But if they're stable, and you know that if you don't do anything, that 4 days from now, 5 days from now, you may need to do something, and you don't want to wait that long. But that's where a second opinion or an ethics board in a hospital or whatever it might be would be appropriate. Again, we're not talking about imminence here. So again, I just want to make sure, and Brent, if you can add something, I want to make sure that we're not unclear or projecting something that is unintentional, but that is very, very clearly our intent. So Brent, do you want to add to that?
Yeah, and again, this is a reoccurring theme, and what we're trying to highlight is that this is not the intent that we had. Is when you're looking at the medical documentation, it's not meant to be a laundry list of things that you had to do every single one of these things. You may need to document about these things that are on there, but it's not that, for example, in number 5, how the decision was made to proceed with an abortion based on reasonable medical judgment, including what diagnostic imaging, test results, medical literature, second opinions, and or medical ethics committees that were used or consulted, and what alternative treatments were attempted and failed or were ruled out. So the purpose here is not to be, well, because of that, I have to do diagnostic imaging, and I have to do testing, and I have to have medical literature, and I have to have a second opinion, and I have to have medical ethics, and I have to, it's just, did you use any of those things at all when you came to the decision that you came to? And if you did use those things, you should document them in the medical record in the event that a complaint is made, because those are things that we're eventually going to go back and ask, like, okay, well, what happened in this situation? Was there imaging that was used? Were there tests that were used? We're going to ask these questions anyways if we ever even get a complaint. I'm sure that we may not. Who knows how many we're going to end up getting? We don't get a whole lot of complaints on this stuff right now. We weren't getting a lot of complaints on it before the law changed. But again, as Dr. Zaffron's saying, our intent was not to make it be that, or make it come across that you had to do every single one of these things and say, here's this, here's this, here's this. But it may be what diagnostic imaging was used? None. There was not enough time. You know, what test results were used? None. There was not enough. I mean, yeah, and so it really is meant to be based on a whole spectrum of how these situations can arise. It may be a true imminent emergency and you don't have time to do any of this extra stuff, or any of this stuff at all, and so you didn't do it. But it may be too, you had days or weeks to come to a decision, and maybe you did have time to use some of these things, and if so, what were they?
Well,
But
in the situation that you described,
yeah,
the situation that you described
respect,
actually, the situation that you described actually was very specific and was very appropriate. You have a patient in the emergency room, the patient's hemorrhaging, you did an ultrasound, the ultrasound gave you a diagnostic result, and you acted on it. That's all you need to do. And then after the fact, that's what you're going to document. I have a patient, they were hemorrhaging, I did an ultrasound, this is what I found, this is what I felt was medically necessary to do to save the patient's life. I mean, it's very straightforward from that standpoint as far as we see it right now.
But with all due respect, under Section B, it says specifically, in addition to the requirements above, the physician must specifically document in the patient's medical record and then the following. So it essentially creates a checklist and says you have to document all of these things. Well, that's the way.
Well, I think there's a lot of and/ors in what your judgment was. I mean, again, when you are going to document something, this is already what you would normally do today if you are going to do this procedure based on the exact type of situation you described. You're going to document that you did what you needed to do based on the circumstance that you're in. Now, the circumstance you're in, you don't have time to get a medical ethics panel together or to get a second opinion, or that's obvious to us because it's an emergent procedure with a patient hemorrhaging. You did one diagnostic procedure that you had time for. And I would argue that if they were even more actively hemorrhaging, you may not even have time to do that, which, again, given the circumstance, that also may be appropriate. I think what's happening here, Brent, and again, I don't know if we can help clarify that, there's a presumption that somebody has to go down that entire checklist and mark everything there, as opposed to these are the things that we would be looking for that would be appropriate for the given scenario that you're describing. Now, if you only did an exam and an ultrasound, and there was nothing that was imminent, the patient's not hemorrhaging, and there's a fetal heartbeat, and the patient's not septic, and you went ahead and performed an abortion, I think there would be a presumption that maybe you didn't do enough to document or be able to document things that needed to be done before you were able to perform the procedure in a legal fashion. But again, it's based on the circumstance and based at what your medical judgment is on that specific scenario at that specific time.
But would her risk of sepsis in that situation be enough?
So risk of sepsis,
it questions the reasonable medical judgment.
So risk of sepsis is something that we just talked about earlier on. I mean, if you're saying that, first of all, do I need to do it 5 minutes from now because she's actively hemorrhaging? Yes, if she's actively hemorrhaging. If she's not actively hemorrhaging, and now you're doing a little bit more testing, you're getting a white count, you're getting a lactic acid, to see if her lactic acid levels are high. Is she becoming a little bit hemodynamically unstable? So that, the appropriate thing may be an hour later or 2 hours later, as opposed to 5 minutes later. Or she may be completely stable and you're not going down that path. Or you may say, you know what, she has cervical incompetence, and if we don't do anything, she is going to become septic. Again, that's your medical judgment. That is probably based on literature. That is based on what a prudent person in a given scenario, in a given situation would exactly do. And again, I think that would be appropriate, presuming that after that, you're going to document, this is why I did it, and this is the logic that I followed, and this is what I felt was necessary to make sure that that the patient was treated appropriately.
And I agree. I think those things would be in there. I think our concerns arise from the fact that the statement actually says the physician must specifically document in the patient's medical record, and then it gives a list of things. So I don't know if we could alter the wording in such a way where it says, should document these things if appropriate, or, because it looks like a checklist.
Okay. I mean, I think that's a reasonable suggestion. We'll take a look at it. I'm hearing a common theme. I hear and I understand that there is a perception out there that is clearly not what we're intending. And I think you will probably see us looking back and seeing how we can further clarify that. I hear you.
Thank you very much. And we really want to work with you on this. And thank you very much for letting us speak.
Thank you. Okay. All right, next, here. All right, so it looks like we had two that may have dropped off. We may come check back with them later from earlier, that names that had already been called. But we'll keep going. And next is Jennifer Allman.
Can you hear me?
Yes, we can.
Great. Hi, my name is Jennifer Allman, and I'm testifying today on behalf of the Texas Catholic Conference of Bishops and the Catholic Health Association of Texas. We would like to thank the medical board for issuing these rules to provide guidance to ensure appropriate medical care is provided to mothers facing pregnancy complications. We've been advocating for rules such as this, and we're grateful for how seriously the medical board is taking the process and the feedback coming from everyone. Women seeking treatment for high-risk pregnancies or who have lost or in the process of losing their unborn babies should never experience a delay in care or be subjected to mental and emotional strain caused by a physician's uncertainty regarding what course of treatment is permissible under Texas law. Yet, as you've heard repeatedly, confusion persists about what the law actually requires, in part because these provisions are spread among various chapters and because there is misinformation spreading in the community. The proposed rules restate Texas laws permitting treatments intended to preserve the health of the pregnant woman that are consistent with the standard of care and law. As indicated in your introduction, the rules do not create new regulations, do not repeal existing regulations, and do not expand or limit an existing regulation. That would be outside of your authority, and we're grateful you've stayed within your authority. However, we strongly encourage the board to consider adding another relevant statute citation, and that's Chapter 74 of the Civil Practice and Remedies Code, Subchapter L. That chapter addresses the civil and criminal liability related to Chapter 165.9 complaints regarding abortions performed. We understand that the board doesn't have any authority in the civil and criminal systems, but I think educating doctors in the rules that this statute exists is very important. This statute states that it's an affirmative defense to liability in civil action and criminal action related to the provider using reasonable medical judgment and providing medical treatment to a pregnant woman in response to an ectopic pregnancy at any location or a pre-viable premature rupture of membranes. Including this section in the proposed rules regarding investigations of disciplinary actions will educate licensees on the defenses and provide them with more assurance that they are acting within the scope of the law. While we understand the board's intent with documentation requirements in the rules, and we generally support strong documentation, we believe the existing statutory standards for documentation are sufficient, and physicians must be allowed discretion to document in a manner appropriate for individual patients and their health needs. Ultimately, it's important to also point out that Catholic hospitals throughout the world have provided life-saving care to women experiencing pregnancy complications while respecting the sanctity of all human life in accordance with church teachings and the ethical and religious directives for Catholic healthcare services. Based on decades of experience of providing life-saving care without providing abortions, we know that it is possible to provide quality, holistic care in a manner that ensures the best outcome for both mothers and babies. We hope that your rule will help other providers to do the same. Thank you.
Appreciate your comments. Saffron, anything? Okay.
No, I think thank you again, and I again I'm hearing the concern about the medical record keeping and so forth, and it's a consistent theme, and again it's something that we'll look at. This is more about making sure that a physician would do what is prudently appropriate, and to document that it's not intended to be a checklist. And again, we'll look at the way the language is written to make sure that that is clear.
Thank you.
Okay, we're about let's see here, it's a couple hours in. So this is a lot of good discussion in this, but I know we want to keep things moving, and people have several to go through. So we'll keep going. Elizabeth Weller.
Hello, can you hear me?
Hello. Yes, we can. Good morning.
Okay, awesome. Good morning. So one of you mentioned that you probably weren't getting a lot of complaints. I forget on what actual part you were talking about, but that you weren't getting a lot of complaints. And so I'm hoping that my testimony here today will kind of clarify why you're not getting a lot of complaints. So my name is Elizabeth Weller, and I am one of the plaintiffs on the Zwarsky versus State of Texas case. So I'm hoping to bring this discussion from the theoretical and into the practical. In May of 2022, I needed a life-saving abortion. I was ultimately turned away and asked to return for the care I needed only once it was clear I had sepsis. Later that year, after finally getting the abortion that I needed, an attorney for the board, Christopher Palazzola, reached out to me to launch a complaint. Only now do I understand why he reached out to me to launch this complaint. During my correspondence with the board, I clarified that I did not want to launch a complaint against my doctor. My doctor was a strong advocate for me to receive care and I was ultimately told by the hospital's administration that I did not qualify for the abortion given the language of the law. I thought I had made myself clear, and at the board's urging, I began the process of filing the complaint on the board's website. But I quickly found out that the website will not proceed with the complaint if a doctor is not named, and no one had told me this before. Frustrated by this process, while emotionally and mentally drained from this ordeal, I abandoned this route. Months later, I joined the Zwarsky case instead. This case places the blame where it belongs, on the state officials who have allowed suffering like mine to continue. This brings me to 3 concerns that I would like to see addressed by the board. First, I would like for us to stop pointing the fingers at individual physicians who are just trying to help their patients under an impossible legal scheme, and stop asking us to do the same. Second, given physicians like mine the kind of practical guidance about the law that they need to be able to protect their patients. And third, and honestly, to me, this is probably one of my most important ones, it's that at the very least, you should bring transparency to the hospital decision-making process in cases like mine. The board wanted me to blame my doctor, but gave me no assistance in determining who at the hospital made the ultimate decision in my case. I want to ask, in these cases of medical boards, is it lawyers or doctors that are actually actively making these decisions at the hospital when we talk about administration? The board does not allow complaints to be filed against hospitals, only doctors. So therefore, I humbly ask the board, can you truthfully commit to looking into these concerns and addressing them? Before I stop it here, because I do have 1 minute and 18 seconds, my attorney will probably not like that I'm taking the rest of that to say other things. I do want to say that in one of the theoreticals that was brought up by another doctor, some of you said that they might have to wait a while to get the care that they need. And I want you to know that I was turned away from the abortion that I needed, and was told to wait 5 days in order for sepsis to occur. And I want you to know that those are the most hellish and nightmarish 5 days of my entire life, as I was forced to wait for my baby to die inside of me and, mentally cope with that. So I hope that, Mr. Zafran, you're right. I hope that these rules are very clear, because in my practical experience of this, it has been anything but clear. And I'm about to say something very drastic, but I feel like I need to do it. I hope that you can all go to sleep at night and that you never have any blood on your hands for the women that are going to have to suffer through this. I hope that your rules are clear. I hope no one has to die because of this. They already have, probably. And I hope that in my life, as I continue to plan my pregnancies, I hope that I'm never in this position again. Thank you.
Ms. Weller, let me just answer you directly here. First of all, I'm so sorry for what you had to go through, and no one can possibly imagine how traumatic that must have felt and been. And certainly, I hope that what we are doing here could prevent you from, or well, prevent anyone else from having to go through anything like that again. As I had mentioned earlier, um, imminence is not something that has to be there for somebody to make that kind of decision. But there's something very, very important that you brought up that I want to make sure that is very clear to everybody who's listening here. In Texas, there is a ban on the corporate practice of medicine. A physician is the only one, or somebody who has delegatory authority from the physician, like a nurse practitioner or a physician assistant, are the only ones who can make or render a medical judgment. No one else can. I understand that happened. I hear you, and that's one of the things. That's why I'm making it very, very specific over here. That if a hospital or if another entity were to make a decision that overruled what a physician wants to do, then we need to hear about that. And you can't file a complaint against an entity that is trying to practice medicine without a license. That happens all the time, whether it's in IV clinics, whether it's in academy,
So
whatever it
I
might be.
I'm not going to argue and say, that that's probably not the case or not. But I do know that when I tried to do so, the website bumped me back because it wasn't a medical doctor, because I also did not have the transparency on my end to say, oh, these are the people who voted against me getting the care I needed. I understand that you're making it very clear that, someone who is not a medical doctor can't override what a medical doctor has decided is the ultimate route to go through. But the fact is that these administrative boards are making these decisions. I don't know what, mental gymnastics have to be made or what legal loops and hurdles are being jumped around to make that the reality of the world that we live in, but that's exactly what's happening. And that's why I wanted to be here, because I hear a lot of argumentative with regard to theory, but not a lot of look at the facts. This is what happens in practice.
Well, I'm going to make it very clear, and I'm committing to you right now that if our website or if our complaint process does not help or facilitate the ability to make a complaint against somebody who's practicing medicine or an entity that is practicing medicine without a license, then we will see what we can do to help make that a lot more clear and facilitate that process. And I'm
So what
hoping
does
that
this
with the rules
do? So what does this do
sorry, go
for,
ahead.
I guess, people who are on the administrative board at these hospitals that are assisting in these decision making, such as lawyers who are helping to decipher the law in this legal, jungle that we're trying to maneuver? What's going on with that? Like, how do we address that aspect of the situation? Because all I see here is that we have come to this very still vague understanding of what we're doing to proceed in order to prevent women like me from suffering through these type of cases. But it seems like we've just come to the next step of a murky juncture.
We lose Dr. Zaffron.
Probably did. But I'll leave it there.
He disappeared. No, I'll just say, what you bring up is a complicated issue. There are attorneys that provide legal advice, but there are medical ethics committees that are comprised of doctors that make decisions also on things that should take place. Like I said, it is very complicated. If there was an issue with our website or some ability for you to start a complaint without having a physician's name to plug in there, again, we are sorry about that. And so that is something that we can try to work through with you and see what revisions we can make.
Okay, well, thank you so much for giving me the time and the space to, air this grievance. And I really hope that going forward, everybody can work together to create a safe environment for pregnant women in Texas, because for a lot of us, it doesn't feel safe.
So thank you for your comments and for being here.
Thank you. Thank you. Goodbye.
Bye. All right, next, Jason Morrow. Jason, are you still
Hey
with
there.
us?
Can you see and hear me?
Yes. I don't see
Right.
you yet, but I can hear you.
Okay. Well, you don't need to see me. So my name is Jason Morrow. I'm an internist. I specialize in.
There,
You can see me.
we see you now. You see you now. Yeah.
Okay. All right. Well, my makeup person was late today, so apologize. So I'm an internist. I do palliative care here in San Antonio. I don't represent anybody but myself, and I'm a clinical ethicist. I help lead an ethics curriculum, and I have some opinions about the statute, and I see what you're trying to do. And your recommended language is trying to strike a balance between recommending, best standard of care and supporting physicians who make decisions within that standard, but also not being so prescriptive that you leave people sort of out on a branch. And I hear a lot of that concern today about the documentation. And on the documentation thing, I don't know, maybe you don't have to say must include all of these elements. Maybe you could say can include standard elements of medical documentation, such as, and then fill in the blank. And I apologize, I didn't get to hear the last couple of speakers because I'm rounding actually. So a few thoughts. Again, whatever you can do to support best practices, I appreciate it. I know there's a lot you can't change, but to the extent that you can advocate for change or that you can add interpretative language and guidance that will be supportive of best practice, I love it. So section 165.7, section A1 and A1B, you refer to the embryo or fetus in place of I'm recommending that you put embryo or fetus in place of unborn child. When wombs hold embryos and fetuses, parents can call fetuses unborn children if they want to. Doing so is an expression of their love and hope, but invoking that phrase in this statute goes too far. It adds a sense of shame and guilt to parents and fetuses that die. Why add that extra emotional burden? I know you can't change that in the other part of the statute, but to the extent that you can use the phrase fetus or embryo and fetus, as you do for the ectopic pregnancy in the other part in section A2, I would do so. Throwing around unborn child a lot just is political. Section A4 of 165.7 defines a medical emergency, but does not give the appropriate context for it. You describe the acute process, a condition aggravated, caused by, or arising from a pregnancy. That's the acute process. That would obviously include things like acute bleeding, ruptured membranes, hypertension, hypotension, pain, or organ injury. But there's no reference to the chronic process that often makes those acute processes high risk for death or substantial impairment of a major bodily function. Pre-existing conditions such as diabetes, obesity, hypertension, cancer, lupus, HIV, advanced age, and psychiatric disorders can all make pregnancy high risk. And a person is healthy until a pregnancy complication arises. And that can be a person can be healthy. But more often, acute complications arise from chronic conditions that make the pregnancy high risk. And some sort of acknowledgement in this section would help give strength to the decisions that physicians make in that particular context. And it would set the table for the type of documentation that would be helpful to have. So I recommend saying medical emergency means a life-threatening physical condition aggravated, caused by, or arising from a pregnancy that in the setting of possible pre-existing or chronic conditions known to cause a high risk of death or injury to the fetus or mother during pregnancy or delivery, and as certified by a physician, places the woman in danger of death or serious risk of substantial impairment of a major bodily function unless an abortion is performed. See what I did there? So major bodily function, in terms of the definition, this is colloquial and it's semi or quasi-medical. It's fine if we recognize that function is a layered term, and function can apply to cells, tissues, organ systems, activities, and the overall health of the individual and the thriving of that individual in a social role. So there's a glaring absence in this bodily function of ones that relate to performance of activities. Namely, you don't mention eating, mobility, toileting, or communicating. And I think that would be important in decision-making for women and their physicians. So, and I also like the other person added renal before. So I would change the language to major bodily function includes, but is not limited to, functions of the digestive, bowel, bladder, neurological, brain, respiratory, circulatory, endocrine, reproductive, renal, and immune systems, which captures sepsis, as well as functions necessary for activities including mobility, eating, toileting, and communicating. So it broadens what major bodily function means in a medically appropriate way. For your exceptions in 165.8 and documentation, let me see what my time is. I can't see both at the same time. Oh boy, I'm out. Okay. Well, you've seen my comments related to documentation and the complaint process. So any questions?
Go ahead and finish your thought. That's fine.
Oh, okay. You're awesome. Thanks. So section B 1 through 4. should read something like so B3 should read something like what pre-existing or chronic conditions and what acute conditions place the woman in danger of death or substantial impairment of a major bodily function. Then you get to B3, the clause is just ambiguous and not helpful. And I like ambiguous to create a space for reasonable decisions amongst physicians and their patients, but I don't like it so ambiguous that we don't know what to actually document. What is it that you mean? So you write, or what was the serious risk of substantial impairment? Well, that's ambiguous. Do you mean what was the serious risk as in what was its nature, like listing the possible harms? Or do you mean its likelihood, like on a Likert scale or a percentage? And I think clarifying that ambiguity would be helpful. And you could just say, or what was the nature and likelihood of serious risk of substantial impairment? Finally, in this section at least, this chapter makes no reference to the patient's values and preferences. Other speakers have commented on this, and this is inconsistent with other chapters and sections of the Health and Safety Code. So out of a concern for autonomy, the legislators have insisted on physician transparency, accountability, etc. I recommend adding with the woman's consent. And this would address the transfer issue the person mentioned earlier. So I recommend adding that phrase so that it would be subsection B would read that the woman gives informed consent to the abortion to include a discussion of the nature, purpose, and likely outcomes of the intervention and of those alternatives, which may not be possible. And I guess finally, if you let me tuck in there on the complaint section, I know that you guys are actually trying to be supportive of physicians. I see that in saying we're not going to have any extra complaints, it's going to be standard fare. But I think that you should go out of your way to say that there won't be additional disciplinary action by the medical board if the foregoing statutory requirements were met. And you can see the language of my recommended statute in the comment.
Thank you so much. You covered a lot of ground there quickly, but I think you made your points very well. One question I have for you, because as you can see, it's a complicated issue. We're trying to get things across. It may not have come across the way we wanted in the proposal that we have before us today, but getting all that in there is challenging into a rule. And the rule can start getting extremely long if we start adding, all these, all kind of the different factors and variables that could go into it. A question for you is, what would you think about if whatever the rule ends up looking like, if the board had some examples or things that came after the passage of the rule to try to say, hey, this is kind of what we mean in these situations, rather instead of it being in the rule itself, giving some examples for people to go by afterwards.
So I like it. I like white papers, commentary, interpretive positions. I would just defer to you all about how much would that help in court, right? It might help with the documentation. It might help practice. So of course I support it. And I'd want to think about how much weight does that carry outside of the actual text of the statute. And I understand you have to balance between being precise and lengthy versus being broad enough and concise enough that it can fit within a statute. And by the way, why not just you guys don't define life-threatening. Seems to me from this conversation here that could be an additional term that is defined, and it's within that you could talk about this concept of imminence, and you could allay concerns that it's not necessarily imminent within hours to days, but it could be life-threatening if allowed to continue for any period of time. So yes, I like a white paper, and I'm available to I love this stuff. I like ethics. I like decision making. I like thinking about emergency decision making. So even others on the call, if I can be helpful, not as under my employer, but just individually, happy to help. So thanks for what you're doing. I really appreciate it.
Thank you. Thank you. Okay, we are about halfway through the speakers at this point. So I think what we're going to do is we're going to take a short break, give everyone a chance to step away, use the restroom, get something to drink, a snack, whatever you may need, stretch your legs. That way you don't walk away and necessarily miss anything that anyone else is saying. So I'm showing it's 15 after right now. Let's give ourselves 10 minutes just to take a break, and we'll come back at 25 after. Thank you.
Hello. Scott, can you hear me? I'm trying to get that ridiculous picture of me from behind me away.
Oh, I thought I was gonna make some comment on that, Dr. Zafran, but
I'm trying to get it
thought
off.
better.
No, and I can't see where I can. It looks stupid.
Interesting.
You can always leave your camera off.
If I can't get that thing off, I'm going to.
Dr. Safran, if you press the three dots, and then do video effects and settings, you should be able to change the background
I don't
picture.
see video settings on here though. Oh, wait a minute. Now, hold on. Let me see. Where's the video settings? Oh, change background. Here we go.
Yeah,
I see it. Mark. Change background.
As much as the picture was lovely.
Yeah, I'm sure you guys love it. I know. There we go. That looked ridiculous.
Alicia, we about ready to go, or are they still working some setting issues?
No, I'm good.
I think we're ready. The next speaker that is signed up may have some troubles unmuting. But if so, I'm gonna ask them to sign out and come back in. But we do have the speaker after that set up ready to go. So we'll see whenever you call her how it goes.
Okay. Well, we'll in the interest of time, we'll get going, and if she's unable to speak right now, then we'll come back to her. All right, we'll get started. Give everyone a few extra minutes here, but we're about halfway through the scheduled time that we have, and we're also about halfway through the speakers. But we will stick around past the scheduled 2 p.m. time if we still have more individuals that we have not gotten to yet on our list or that have joined us and would like to talk. So don't worry, you will get your opportunity. So next up is Lauren Miller.
Good afternoon. Okay.
Yes, we can hear you.
Wonderful. Thank you.
Yeah, you'll have
I'm sorry.
4
My
minutes.
apologies. I'm sick, so just trying to talk.
No, that's okay. Take your time. You got 4 minutes, and the floor is yours.
Thank you. My name is Lauren Miller, and I live in Dallas. Vague and confusing state-mandated bans on essential medical treatment delayed my access to abortion care, creating an unnecessary, life-threatening medical emergency. It also forced me to speak in code with my medical team as I tried to navigate a devastating diagnosis. Just weeks into my second pregnancy, I wound up in the emergency room following 36 hours of unrelenting nausea and vomiting. It was there while being treated for severe dehydration that we learned I was carrying twins. I was so sick, but so excited. Then at the routine 12-week ultrasound, everything changed. The doctor explained that while one of the twins was thriving, the other was not. On the scan, she pointed out 2 large fluid masses where his brain should have been developing. More testing brought even more horrible, fatal diagnoses. In speaking with our team of doctors, nurses, and genetic counselors, we kept arriving at the same awful conclusion. This twin was going to die. It was just a matter of how soon. And every day that he continued to grow, he put our healthy twin and myself at greater health risk. But because of Texas's new abortion laws, my doctors were terrified to suggest an abortion of the twin that would never survive, even though this would have saved the other twin. There were no next steps. There were no treatment options. It was a devastating diagnosis, and we had reached the point where healthcare ends in Texas. The state of Texas would kill all 3 of us rather than let my doctor and I determine what was best for me in Texas. During another emergency room visit here, I was vomiting so severely that I thought the placenta would detach and I would bleed out. I was severely dehydrated and shaking uncontrollably as the team in the emergency room worked to stabilize me. I was at risk of organ damage to the kidneys or brain. Can you imagine trying to get necessary medical care when your doctor can't give you the treatment you need and is afraid to explain or even say what your possible treatment options are? In Texas now, these cruel, inhumane laws trump and paralyze the good judgment, experience, and training of caring medical professionals and result in a stunning lack of options for patients like me. Abortion bans have eliminated emergency reproductive care in Texas, and I am living proof of that. I was able to leave the state for an abortion, but I know many others have not been so lucky. The Texas Medical Board can fix this, but not with this extensive and new laundry list of things doctors must check off during a medical emergency before they can offer the standard of care, an abortion. These new regulations will have the opposite effect of helping or clarifying the law. And the rules wouldn't have helped me or my son Henry, who is now a thriving toddler, precisely because I got an abortion out of state. You must find another way to return the power to physicians to speak openly and honestly with patients and do what is right to protect their health and future fertility without fear of professional or criminal penalties. After all, where else in medicine do doctors have to justify their life-saving treatments except when it comes to pregnant people? Thank you.
Well, thank you for your comments and for sharing your story. We are all saddened and sorry for what you had to go through during your pregnancy. But again, it's important that you're here and giving us this feedback, and it's something that we'll take a look at as we continue to go through the rulemaking process.
Thank you. I appreciate your consideration, and I know you're trying to come up with ways for doctors to have alternatives for abortion care. That was something that they were trying to do for me, but it still would not have helped. The solution at that second ER visit was a plan for that when I would be back the next time, because there was just a when, not an if, that I would be admitted long term, which is not something I could handle with a toddler at home, and it still would not have saved Henry. So I thank you for your consideration today, and I welcome if I can be a part of this process in the future.
Thank you.
Thanks.
Next is Kate Cox.
I needed an abortion in December of last year. I asked my state for help, but the Texas Supreme Court's decision didn't help me. Instead, the court pointed me to this board, the Texas Medical Board. I'm afraid the rules this board are now proposing wouldn't have helped me either. I keep hearing the leaders of our state saying the physicians are to blame. My physicians are trusted and capable. Some say it's a matter of semantics, of which words a physician must use. But I can see that the problem runs much deeper. The new rules will create additional hurdles for patients like me who are just trying to access healthcare we need. I don't think most people understand just how severe the abortion laws are in Texas. By denying me the abortion care I needed for my health and future fertility, the state, my state, was cruel to my family and I. I was pregnant with a baby that would never survive and could jeopardize my health and a future pregnancy. I spent evenings sick on the bathroom floor instead of having dinner with my family. I spent nights in the ER instead of reading bedtime stories to my children. I lived in fear of my health while I waited until I was sick enough to get an abortion or for the inevitable and unavoidable loss of my baby. I was fighting to ensure that I would be healthy enough to be the mother my two small children need. I'm afraid women and families in our state will continue to suffer. We will continue to go without care. All of my diagnostic tests were clear. There was no other medical literature to consult, no alternative treatments, no other procedures, and nowhere to transfer me. The Texas Medical Board's mission is to protect the public's health and safety. You'll hear from numerous mothers today. We're not safe. The Texas Medical Board's mission is ensuring quality health care for the citizens of Texas through licensure, discipline, and education. So please educate lawmakers, listen to our OBGYNs. You said that the Texas Medical Board doesn't have the ability to make a new rule, but you are a defendant in my lawsuit, and you could have taken the position in litigation that I should have been able to get an abortion in Texas, but you didn't. As it was, while trying to grieve our inevitable loss, I had to make my own way out of state for essential and humane medical care. The best medical treatment for me was an abortion. Our state should not force us to put ourselves through the risk to our health and mental anguish of carrying a pregnancy with a fatal fetal diagnosis. We should not force pregnant Texans to get sicker, to wait for an inevitable miscarriage and go through childbirth to deliver a baby that has died or will certainly die. It is medically reasonable to give mothers and families the best chance at building their families, which may include terminating a non-viable pregnancy so they can have a chance at a viable one. I needed that chance. Thank you very much for your time.
Again, very sorry for everything you went through, the complications. I can't imagine how difficult that must have been for you and your family. But we are very appreciative that you're here and that you are giving us this feedback. And these are things that we will take back as we go through this lengthy process. And it's because of people like you and everyone else that's here that'll help, hopefully, help guide us to make the rule better.
Thank you.
Thank you. Next, Amy O'Donnell.
Hello, I am Amy O'Donnell. I'm so grateful for this time with you all today. I'm the Communications Director at Texas Alliance for Life, and I'm here to comment on the draft rules promulgated by you all at the Texas Medical Board regarding explaining to physicians the meaning of the medical necessity section of the Human Life Protection Act, which is the law to protect unborn babies from abortion that the legislature passed in 2021 during the 87th regular session. We are grateful to the board for its actions to date. It's important to note, as you consider this important issue, that Texas abortion laws are currently saving unborn babies and pregnant women's lives. Induced abortions performed in Texas are required to be reported to the Texas Health and Human Services Commission. The numbers are recorded on a monthly basis in the Induced Termination of Pregnancy reports, also known as ITOP. The latest information from the reports shows two relevant trends. First, the law is saving unborn babies' lives. Reported elective abortions plummeted from thousands per month to zero after Dobbs reversed. Second, the law is saving pregnant women's lives. During the first 16 months after Dobbs, from July of 2022 through December of 2023, the latest month of available data, doctors performed 81 abortions, all in hospitals, that fell under the medical necessity exception of the law, Section 170A.002 of the Health and Safety Code, to save pregnant women's lives or prevent the risk of a loss of a major bodily function. We believe that fertility is a major bodily function. No doctor has been prosecuted by a district attorney, sanctioned by this board, or sued by the attorney general. No pregnant woman has lost her life for lack of an exception, even with the more than 360,000 births in Texas each year. This shows that the exception in the law allows doctors to perform abortions to save pregnant women's lives in rare and tragic cases when medically necessary. We have not submitted written comments regarding this yet, but we will do that soon. Today, I will make 3 points on behalf of Texas Alliance for Life. First, we recommend clarifying that a doctor can perform an abortion when a woman's pregnancy endangers her life, but that her death does not have to be imminent. In the Texas Supreme Court's December 8th, 2023 opinion in RE Texas, the court was absolutely clear on that point. And second, along with that point, we suggest substituting the term medical necessity for medical emergency. We think it is telling that the Supreme Court used the term medical necessity throughout its opinion and never used the term emergency. Third, we note that the court only referenced the exception language in Chapter 170A, Health and Safety Code, the Human Life Protection Act, and no other abortion-related laws. We believe this is a strong indication that the court regards Chapter 170A as the controlling law and the only law that doctors need to look at in cases that involve medical necessity abortions. We believe these rules should reflect that. Thank you for considering our comments.
Thank you. I appreciate the feedback you provided. I will say that from the medical board's perspective, what you mentioned does kind of highlight something for us that's been a bit difficult for us to reconcile at times is we know that these procedures are taking place out there, like as you mentioned, the documentation for them. They are happening, and we're not receiving complaints about those procedures that are taking place. So it does kind of make it difficult at times to kind of maybe see where it is to strike that right balance in opening it up more for doctors, and maybe being more specific in our language about specific protections and guidance we can give, versus being a little more kind of open-ended for doctors to make these decisions. To get across today, our goal is to provide doctors that space to kind of work in, and kind of how to document it if that's the decision that they make, and what they could expect from the board as far as questions if we ever did get a complaint about the procedure. But so far, again, we know they're happening for medical exceptions, but we're not getting complaints that they're being done inappropriately, as you referenced. So it is something that is in our minds when we're crafting this proposed language, and it'll be something we consider as we go forward in this process.
Thank you.
Thank you. Amanda Zarowski.
I do see an Amanda in the list. They don't have a last name listed, but okay, I did unmute you, Amanda, so you should be able to speak now.
Thank you. Sorry, I couldn't figure out how to change my name.
No worries.
So thank you for having me. Can you hear me okay?
Yes, we can.
Okay, great. So thanks for having me. Good morning, everyone. And thank you for taking the time today to discuss these proposed regulations and for allowing the public to weigh in and provide comment. As mentioned, my name is Amanda Zarowski, and I nearly died as a result of being denied basic health care that I needed while I was pregnant with my desperately wanted baby in the summer of 2022. When I received the crushing news that my husband and Josh and I were going to lose our baby girl at 18 weeks, at that point, my doctor should have been able to induce labor so that I could deliver our daughter and begin healing, both physically and emotionally. But with the way the law in Texas is currently written, an induction would have been considered an illegal abortion as long as the baby's heart was still beating. So I had to wait until I was in septic shock, literally on death's door, before my healthcare team could provide the care that I deserved and needed. In less than 10 minutes, I went from being physically fine to being consumed by a deadly infection that nearly killed me. My doctors stabilized me enough to deliver our baby, but then I quickly went back into septic shock with another deadly infection, whereupon I was immediately transferred to the ICU. Doctors and nurses fiercely stood by me, working through the night to save my life. Every minute was critical. Every second that passed posed a greater and more dire threat to my life. As a matter of fact, my healthcare team told my husband to call our family so that they could fly to Austin and say what they thought would be their final goodbyes. As you can see, I'm very much alive today and sitting here because of those healthcare professionals. But I'm here right now because I'm alarmed at the state of healthcare in Texas. Had my doctors waited even minutes more to provide care, I don't think I would be here. My reproductive organs have been permanently compromised as a result of the infection that unnecessarily consumed my body. And nothing that happened to me was inevitable. It was all caused by the confusion and fear that's been placed upon doctors in our state over abortion care, which is the standard of care for an urgent, emergent situation like mine. The regulations you're proposing clarify nothing and only further complicate patients' ability to access healthcare. You've effectively created a detailed checklist that doctors must meet before they can provide treatment, which in many cases might be life-saving. You know that in dire cases like mine, every minute is critical. My healthcare team had a difficult enough time in providing treatment for me, and if they had been forced to jump through all the additional hurdles you've now proposed, would I still be talking to you today? Doctors take an an ethical oath to do no harm, but I fear that what you're proposing here will in fact continue to force them to violate that oath. What happened to me was needless and senseless. Please do not make it worse. Thank you.
Thank you for your comments. Again, I'm very sorry for the experience you had and the difficulty you had with your pregnancy. Having to wait till you're in septic shock is certainly not anything that we want, and that's again what we're trying to make clear here is that patients do not have to be at that stage before getting treatment. One thing I do want to clarify in regards to this a comment you made is, and I know people are coming in and out and joining, so you may not have been on earlier when maybe some of this was discussed, and maybe some others are in the same situation. But we do want to make clear that the way the rules, the intention of the rules, is not that a physician has to go through all of those things and try all of those things out before giving care. But those are things that would need to be documented after the fact, especially if it's during an active, emergency, someone in the situation that you were in. So I did want to just make that clarification, and that is, feedback we've received from several people interpreting the rule as meaning that's something they have to do before they can provide the care. Again, that's not our intent. That's not what we were going for. So we'll look at how we can clarify that in further revisions for the rule. But in the situation you had, a physician would not have been required to do all of those things and take more time to save your life.
I appreciate that, and I really do hope that we can help clarify that and make sure that doctors really understand that, because I think about and I worry about if my doctor was confused or didn't understand that they would have to go through this checklist, or they would have to consult with X number of people, or they would have to explore transferring me. All of those things would have delayed me getting care. And as I mentioned, had I been delayed from getting what I needed much longer, I probably would have died. And so I really hope that we can clarify that for doctors and make sure that they are just crystal clear on what that means.
Yeah, just
yeah.
yeah.
Go ahead,
To highlight what Brent said. I mean, just again, a couple of things. Number one, I don't know again what the circumstance was when you went the first time, and whether there was a reasonable idea from your physicians that if you were to wait, that you would potentially become septic. But if that was the case, then they should have been able to act at that time. And if you were stable at that time, yes, it may have required some testing again, or consultation. Basically, just looking at the fact that if you were to wait 5 days, then potentially you would potentially proceed onto septic shock or into sepsis in general. That's one scenario. The second scenario, where when you were in sepsis, nothing should have been delayed or would have been delayed as far as your care is concerned, as Brent just highlighted. All those things would need to proceed on, as fast as possible to make sure that interventions were made to save your life. What we're saying is the documentation needed afterwards would be the normal documentation needed to highlight why they did what they did. And again, that's really nothing more than what a physician would do today. I understand, again, as Brent highlighted, that some may be looking at this as a checklist that needs to be filled from A to Z. That is not the intent. And again, we'll see how we can clarify that. But again, just kind of going back 5 days earlier from your incident, again, maybe the case was that nobody would have thought that maybe you would have proceeded on to sepsis, or maybe there was a reasonable idea that somebody thought you would proceed on to sepsis. And if that was the case, interventions could have happened then, again, with the appropriate documentation and so forth. So I hope that clarifies things. But again, we hear you. And again, I think that we're going to look and see how we can further enhance and help facilitate that message going out.
Yeah, I appreciate that. And I hear that you are going to work to clarify that. And I hope that we can, because, even though I understand it's not the intent of the board to create this checklist, we've heard from a number of physicians today who are here telling us that they view it as a checklist. And so clearly there needs to be an additional layer of clarification there. And I'm really hopeful that we can get to that. So thank you
so much for your time and your comments. Next is Karen Fox.
Hi, all. Thank you. Thank you so much. My name is Karin Fox. Hang on, let me mute myself on my end so I don't hear myself talking. No, mute the. Hang on just a second. There we go. My name is Karin Fox. I am a board certified OBGYN, professor of maternal fetal medicine at the University of Texas Medical Branch at Galveston. Prior to coming here last January, I led the placenta accreta spectrum team at Texas Children's and Baylor College of Medicine, and am on the board of the Pan American Society for Placenta Accreta Spectrum and the International Society for the Placenta Accreta Spectrum. So essentially dealing with some of the highest risk pregnancies, I've worked at 3 level 4 maternal care centers and appreciate all that the Texas Medical Board does to try to keep our patients safe. Incidentally, I have also served as an expert reviewer for the Texas Medical Board and understand that what your job is to really try to protect the health of patients in the state of Texas. There are a couple of issues that have already been stated by others within the group that I don't want to review over and over again, but I think may lead to some clarity. It has been my experience trying to write recommendations, guidelines, or also in other careers. Before I came to medicine, I was in the military. When you are creating guidelines or some type of guidance, language really matters. I've also lived in other countries, have to speak different languages with folks, and the language of the code is going to be the true source of truth when things go to litigation. So I think having absolute clarity of what is the minimum standard versus what is necessary must be in this code, not just in a white paper, as was discussed earlier by Dr. Morrow. That's number one. Number two, I've heard a couple of comments that talk about different scenarios that may or may not occur during pregnancy. Thankfully, the American College of OBGYNs and the Society for Maternal Fetal Medicine have some very clear guidelines about what treatment options are appropriate under certain circumstances. For example, preterm premature rupture of membranes with a bag of water breaks. We know, especially when this happens before 20 weeks of gestation, there is a very high risk for infection. So we've talked about the contingency of sepsis. Sepsis in the setting of rupture of membranes is extremely dangerous, and actually infection around that fetus or unborn baby, depending how you want to look at it, I still prefer the term fetus using the medical terminology, is never good for that neonate if the baby must be delivered. If this is before an age of viability, however, we still have to think about the impact on that mother's life and her reproductive capacity in the future. So sepsis because of something like a kidney infection or bladder infection or influenza or COVID is very different from sepsis because of something that is pregnancy related. That is not clear when we have these discussions about sepsis as a contingency. Second, I also have served as the Director of Maternal Transport for a Level 4 maternal facility, and I'm on the National Association of EMS Physicians. And when we talk about especially rule number 7 or topic number 7 about transfer to a higher level of care, number one, most facilities are really trying to transfer their patients out when they're complex. Again, we have levels of care in the state of Texas, which helps give that guidance. The problem is Texas is a state that is about as big as the whole continent of Europe. Houston itself is about the size of the Netherlands. And it's not just a matter of getting somebody from one hospital to another, not just whether or not we transport, but how long is it going to take for that patient to get to that higher level of care? The length of time for somebody to be transported, the condition that they're in prior to that transport plays a huge role into whether or not it's a safe transfer. Or if somebody does have a condition, maybe it's not imminent, but still some time, that patient's condition may deteriorate during a transport, which then puts that emergency medical services team, that ambulance driver, the paramedic, in dire straits if that patient is then acutely becoming ill, especially if we're talking about a long transfer, where somebody may be coming, for example, from El Paso or Abilene all the way to Houston because of a very unique circumstance. And placenta accreta spectrum is one of them. So let me describe very briefly, for those of you who are not aware, placenta accreta spectrum often arises after the implantation of an embryo into a cesarean scar. Technically still within the uterus, but it is truly an ectopic pregnancy because it is not within the normal endometrial cavity or the lining of the uterus, but inside a scar, a defect in the uterus. Or there's also a condition called a corneal ectopic pregnancy, where the
fetus in the embryo is implanted within the uterine muscle, not a normal pregnancy that cannot continue, both of which pose the risk to uterine rupture, massive hemorrhage, and loss of either the uterus or the life of the mother. So we have a conflict even within this statute as it states. What is the definition of an ectopic pregnancy and what conditions we can treat? I would urge the board please to simplify the regulations. I agree with the previous call to remove bullet points 5 through 7, because again, they cause an undue burden for documentation and a lack of clarity that is unnecessary considering the already existing burden for documentation. And I thank you for your time.
Thank you. Appreciate your comments. And we certainly hear you on what you're saying, especially about your comments on the transportation piece of it. I mean, again, for us, it was certainly never something that was contemplated of, well, just transfer the patient, even if it means that they could deteriorate or they're not stable for transportation or things of that nature. But certainly hear what you're saying on what the potential complications of documenting something like that is. So thank you.
And just to add in there, and you know, you've been a reviewer, as you stated, and when we talk about, you know, physicians looking at what the standard of care is, what the literature says, what the associations say, all that kind of stuff. I mean, isn't that exactly what we're saying also in the rule? I mean, I think you're highlighting exactly the point that we're making, that a physician, you know, and by the way, I've done accretas as an anesthesiologist, and it's probably one of the most feared things for us to do, you know, as far as potential blood loss, as far as like complications and so forth. Certainly not the kind of thing that you want to do in a small community hospital out in West Texas. I get it. But I think your point actually highlights exactly what we're trying to say, is that there isn't a clear answer in every single given scenario, that you do have to kind of highlight what the associations say, what the experts say. And I think that's what we're trying to actually put out there. You know, the idea of not putting a checklist actually is exactly for the reason why you're stating. I mean, not every single situation is the same, but the idea of documenting, again, if it's emergent after the fact, but if it's not emergent, you know, again, like you normally would beforehand, is exactly kind of along the lines that you're talking about. Now, again, I understand that maybe there's some confusion as to listing everything that is on those list that we have from 1 to 7, and I don't think that's the intent. And there's something, you know, we may look at helping to clarify that. But from the overall construct of things, I think we're kind of saying the same thing.
Well, I think we have that potential. Let me turn this down again. So I think where the clarity needs to happen, I have no problems with proper documentation. I think that needs to occur. And I think that is helpful also as a reviewer. Where I have concerns are two things. I agree with the recommendation. It needs to say somewhere here that, again, that the documentation, even where it talks about documentation in this rule, that it can happen before or after the time of the treatment, depending upon the urgency of the situation. Something to that effect would be helpful. And again, making sure that the or is there, or that not all of those requirements are necessary in order to meet the burden of proof. Right now, it feels like the burden of proof is on the physician to justify exactly what we did, as opposed to just using medical rationale. For example, if I have previously done an ultrasound that shows that there is a condition that warrants immediate delivery, such as, again, I've done the exam for rupture of membranes, there is no fluid around the baby. Again, we have a condition that we can't predict when it might go to infection, but left long enough, it will cause infection, and it's within the guidelines to proceed. That should all that needs to be said. I should not have to document once again that I've done the ultrasound if the ultrasound is documented within my medical record.
Yeah, and I think your suggestions are very helpful and timely, and you actually brought up the point. I'm going to use the example of the accreta again, because I think it's a good example. So if a patient presents to a community hospital with a placenta accreta and they're stable, I mean, we are talking about very, early on in the pregnancy. And I know that in the area that I'm at, that I'm in a place where I don't have the ability to have good intensive care, an operating room that, has the ability to do an arterial line, central line, giving blood, all that kind of stuff. But I'm very early on in the process, and my suggestion to that patient is to transfer them to an area like, Texas Children's or, Texas Women, whatever that might be, where once they get to a point where they are ready to deliver, it's going to be something that they need to be at a higher level of care, versus if that patient came in as a Necreta and they're already starting to bleed, or I have a concern that they're unstable, then in that instance, transfer would not be appropriate. And I may need to actually take more immediate action right there and then. So I think we're kind of saying the same thing. And you're highlighting why the same situation under two different circumstances may necessitate two different actions. But your point about highlighting how it's documented and all that, I think is very well taken. But I think you're kind of actually showcasing why we said some of the things that we said for those same exact reasons.
Well, yeah, and that's greatly appreciated that is the intent. I'm hearing also that the intent is to provide that clarity. As it reads, it doesn't seem that clear. So I think again, we can get to a point where it is both, again, that balance between enough information without being overly prescriptive. And I greatly appreciate the board's time.
So thank you. Again, as a trend, I've had several individuals make the recommendation of perhaps dropping 5, 6, and 7 from part of the rule there in 168.5 and the proposed version of it. Just wanted to highlight real quick, we haven't mentioned it yet, but the number 6 on how the determination was made that performing a procedure in such a way as to give the child the best opportunity to survive would create a greater risk to the woman. That is tying back to statutory language that's in 170A already. And so that is something, a consideration that a physician is already going to have to make. And so that's part of why we put it in there, is it is piece of an already statutory requirement in going through this analysis of performing an abortion. And so we're trying to make that clear that they need to be sure and document that piece of it. So anyway, just wanted to highlight that because it has come up a few times and we hadn't kind of touched on kind of where that came from. But again, your points are taken on some of the challenges of perhaps getting all of this in. All right, next is Wendy Davis.
Hello, can you hear me?
Yes, we can.
Hello, good afternoon. My name is Wendy Davis. I'm a former state senator and now senior advisor at Planned Parenthood Texas Votes. Today, I am representing that organization, as well as Planned Parenthood of Greater Texas, Inc., Planned Parenthood Gulf Coast, and Planned Parenthood South Texas. We want to start by commending the board for its efforts to compile relevant definitions in existing law into a single location through the proposed Chapter 165.7. However, like many others, we believe that certain terms in Texas abortion law need further clarification. As a first step, we recommend that the definitions section more specifically define serious risk and substantial impairment according to Chapter 171 of the Texas Health and Safety Code. The definitions section should emphasize that the medical emergency exception includes not only cases of life-threatening conditions, which are also not defined, by the way, but also situations when abortion is necessary to prevent serious risk or significant impairment. It is crucial that doctors have clear guidance, particularly considering that they may spend the rest of their lives in prison if someone else, after the fact, determines that their actions were not reasonable in accordance with the statute. We also urge, as so many others have done, that you address Section 165.8b, which requires physicians to provide necessary documentation for medical emergency abortions. That requirement, which goes beyond standard medical practice, may hinder timely access. And I understand that you've answered some of those current concerns today, and I appreciate that, as I know others do. Further, Section 165.9 does not address concerns about the uncertainty surrounding the applications of the medical emergency exception. In light of the dire reproductive health care crisis in Texas, physicians' ability to exercise medical judgment must be clarified. Their confusion and fear has been exacerbated by the fact that the state of Texas not long ago sued to block application of the Federal Emergency Medical Treatment and Labor Act, which at its core requires no more than that an abortion be provided where necessary to stabilize the life of a pregnant patient in need of emergency care. If the medical emergency exception doesn't cover that instance, what does it possibly cover? And though the board has indicated that the latitude granted to physicians in the case of imminence is clear, the reality on the ground is that it is not. And without the presumption that a doctor acted reasonably, her judgment can be second guessed by someone who is cherry picked to say that it was not in a criminal case. As others have also said, it is also important to incorporate the recent clarifications issued by the Texas Supreme Court in the Cox case regarding the medical emergency exception, including the fact that the court emphasized it is not necessary that all doctors would agree on a particular plan of action in the event of a medical emergency. Texas healthcare providers will receive valuable guidance by including this binding legal interpretation in the definitions section. I understand the concern you earlier expressed that the board can't include language from every court decision. But this is the first time the Texas Supreme Court has provided any clarification on what has obviously been an incredibly confusing statute with a high stakes outcome for doctors and hospitals if they get it wrong. In the aftermath of Texas abortion bans, Texans have faced severe limitations in access to reproductive health care, resulting in dire consequences such as higher maternal mortality rates and increasing health disparities, particularly in marginalized communities. We urge the board to amend the proposed rules accordingly to address the urgent needs of Texans seeking needed and necessary reproductive health care. Politicians should not interfere with Texans' access to comprehensive, timely, and life-saving health care, and your consideration of our comments and your action to protect the health and rights of Texans is greatly appreciated. Thank you very much.
Thank you for your comments. Again, you covered some good points and things, and highlighting some things that others has said before you. And so again, we hear you and everyone, kind of loud and clear on your concerns on it, and we'll certainly take that back as something to look at future revisions. Dr. Zafran, do you have anything?
No, Wendy, again, thank you for being here. I used to work with you as a state senator in the past when you were representing the medical center and that area. So yeah, thank you for your previous service and thank you for your comments.
Thank you, Dr. Zafran. Thank you all.
Thank you. Sarah Harrison.
Hi, good afternoon now.
Hello, good afternoon.
Yes, my name is Sarah Harrison, and I'm here today to talk about one specific thing and the rule that you are proposing, which is the definition section. There's the definition of an act not being an abortion, and in that section it says that an act is not an abortion if it's done with the intent to save the life or preserve the health of an unborn child. And I'm here to ask the board to clarify, what does preserve the health of an unborn child mean? I think that it requires some clarity for doctors and is quite ambiguous as drafted. On May 1st of this year, just 20 days ago, I gave birth to a healthy baby boy, and I was able to mitigate the risk to myself and my son because I received excellent care in Colorado late last year. At 17 weeks, we had a diagnostic test confirm that the other fetus in the pregnancy, baby B at the time, had a fatal fetal anomaly. This is a very similar case to Lauren Miller's The doctors told us no doctor would operate on this baby. The hole inside baby B's heart was too big. And he would not live either through the pregnancy or for sure after. And because of the Texas law, no doctor would offer us the option to do a reduction, especially with the threat of criminal prosecution. So we left the state to receive the care we needed, which was, to be frank, quite dystopian to have to leave my home to receive the care that my doctors before the Texas law was in effect could have provided me. And I could have spent time focusing on grieving my, the loss of part of this pregnancy, instead of being enraged by the fact that I had to leave the state to receive that care. So I'm here today to ask about what does preserve the health in this definition mean? It's my understanding that it's not the intent of the board for women in my situation and in Lauren's situation to have to travel out of the state to reduce a pregnancy when carrying a multiple pregnancy with one fatal fetal anomaly puts at risk not only my life and health, but also the other, and any other woman carrying a multiple pregnancy, but also the other fetuses involved that are determined to be healthy. So I think that if your intent is for this rule to mean that an act is not an abortion, if the act is done when a woman is carrying multiples and one fetus has a lethal fatal anomaly, then you should say so. It should be very explicit. Preserve the health seems quite ambiguous to me. And I have thoughts on what that could mean, but I would defer to doctors. But in my case, the risks were high that there would be a preterm delivery, that I would have preeclampsia, that I would have a C-section. And I think all of those are valid reasons to reduce a pregnancy in my case. And I'll stop there.
Thank you for your comments. Again, I'm sorry for the difficulties that you had with your pregnancy. To try to answer your question, what that part is looking at is already an existing statute elsewhere. You said it's in the definitions piece, so it's not something that the medical board wrote or came up with, but we're trying to compile to make it a little bit easier to find some of this information. In the scenario you were talking about for yourself, I think where you would see it apply is if it was just a single fetus that you were carrying at the time, and a physician tried to do something to repair the hole in the heart, or do some sort of procedure to preserve the health and the life of the fetus. I think that's where it's looking at that. Of if for some reason it wasn't successful, and the fetus expired while trying to save it, that would not be considered. That's a type of act that would not be considered an abortion.
Oh, so you're saying that doesn't, so the definition wouldn't actually apply in my case at all. That the act of terminating the fatal fetal anomaly to save or preserve the health of the other fetus is not included in that.
Well, what I'm saying is, it's much clearer if you're looking at it in the sense of there's just a single pregnancy, one fetus at a time. I'm saying in the case where there's multiples, again, that gets a little bit different than what the statute is particularly talking about. And for the purposes of today, of what we're talking about, of the medical board's proposed rule, it's not talking specifically about fatal fetal anomalies. It's more focused on the emergency piece of it. And so that's about, I guess, as far as I can go and to answer your question at this time. But if the recommendation that you have of looking at the rule is that we add something about fatal fetal anomalies and how that plays into pregnancies specifically, then that's feedback we can take and look at potentially seeing about adding that to the rule. or having a separate rule specific to that. But that would be feedback you could provide to us.
Yeah, I just think it underscored, like, if this is not considering the life of other healthy children or of fetuses that would be healthy children once they're born, it just underscores the fact that, like, this isn't about saving lives. Because mine and Lauren's case was clear that, you know, and Kate Cox's as well, that the fetus was had no chance of living outside the womb. So it's really forcing a woman. And in my case, I just had a very complicated and scary delivery with my son, and I just kept thinking about how would this be if I had to also birth a stillborn baby, and how awful that would be, both emotionally and physically. And I'm still physically recovering, and it's yeah, this is very shocking to hear that this isn't also in consideration of healthy babies that, you know, could be born if a reduction occurred, knowing that the reduction would be for a fetus that can't live.
Ms. Harrison, so we talked a lot about standard of care and about what the associations would recommend and so forth. And, you know, we had some experts who are actually testifying earlier on. So I'm not going to purport to be one of those experts. But I don't want to presuppose, but if you had seen a physician and in their judgment and based on the literature and based on, you know, what the association recommendations are, if carrying a stillborn fetus along with another viable fetus would harm the other, and their recommendation, and based on the literature and the association recommendation, is that something different be done, then that would be an argument that the physician could make potentially, if that was the case, in that scenario, as to how that should proceed. Again, I don't know because I'm not the expert. But if a physician, if a gynecologist who saw you would make that recommendation, and if you remember with Katie Cox, I mean, actually the Supreme Court said that unfortunately it was a matter of semantics for that physician, but they said that the way it was described, given a different scenario, that the Supreme Court might have actually proceeded on and said that it would have been okay. And again, that's why I think it's a little bit difficult to get into the specifics, but it does go back to what the associations say, what the recommendations say, what the standard of care is. And if that's something that they would say and recommend as being the standard of care in your case, in your scenario, then it would apply. Again, I'm trying to be very careful about getting into specifics because I don't know and I'm not the expert. But if the experts opine that way, then that is something that we would say is okay. Brent, am I off on that, or you know, I just want to make sure that I'm kind of going along those lines.
But of course, I mean, my doctors of course said that this is the standard of care, and it was prior to the law, but that they, under threat of criminal prosecution and losing their license, they were not going to provide a reduction because they couldn't prove that I was at serious risk of losing my life or serious bodily function. So it would have absolutely been the standard of care to provide a reduction in my case, but the law prohibits that. So yeah, I don't know what else they would need to show, but that, like, carrying multiples is high risk, right? Like, carrying multiples carries the high risk of preterm labor, and a lot of other things, a lot of other complications. I'm older, I'm 38. And so you know, this is
yeah, there's also complications that arise from carrying a non-viable fetus to term. So that's again where the experts would be able to opine. That's where the experts would be able to opine. Again, I don't know the specifics, but if they were to opine that there are risk factors from the standpoint of sepsis or other complications, bleeding, you know, all that kind of stuff, then it would be up.
Like, at what point is, like, you know, a cancerous mole, are you going to die from cancer, right? Like, it's like, at what point does it reach the level in the law that allows for that kind of care, which getting it early is more important, right? Like, my husband and I talked about litigation the weekend before we left for Colorado. And we decided against it because the longer you wait to do a reduction, the longer the longer you wait, the higher risk it is to the other fetus, to the whole pregnancy, right? So like we were already at 17 weeks because we needed to wait till 16 weeks to do the diagnostic test. And so had we waited even longer, we were putting Max, my current son, at risk and the whole pregnancy at risk. And so we decided against that. And so like, we couldn't wait till I was, you know, till there was harm to me or there was harm to Max, right? It had to still be kind of theoretical. But we knew that there were high risks eventually. So that's why this law is quite horrible, because women can't get the standard of care until they're up to the brink of, you know, dying or losing serious bodily functions. Yeah.
We hear your concerns. Again, we appreciate your comments. And it's something we will take back and look and see. So
Yeah.
I appreciate it.
And legislators know these kinds of situations exist, right? But they didn't put these exceptions into law because they expect women to carry these pregnancies to term and suffer the consequences. They know these things exist and they didn't make the exception. And I appreciate y'all trying to make this clearer for doctors, but this was the intent, is to put us through this. And that's really awful.
Yeah, thank you, and congratulations on the birth of your son. Next is Austin Denard.
Can you guys hear me okay?
Yes.
My name is Austin Denard. I'm a working OBGYN in private practice here in Dallas. I'm board certified. I'm a mother of 3 children, and I've been in Texas for, my family's been in Texas for 6 generations. I'm here to comment on the newly proposed regulations as a physician who treats pregnant patients 5 days a week. I'm sitting here in my office right now. And I will say that my thoughts are my own, and they do not represent the thoughts of my hospital in particular. I've been a patient who has suffered from having my own pregnancy that had anencephaly, which all of you on this call know is a fatal fetal anomaly. And I myself had to flee my state to get care. Now, all of us know that that should not happen, right? It's in the spirit that I bring in my comments today as a working OBGYN and mother who has suffered all of this trauma of the abortion bans. You all should know that all of my patients, 2 of whom I saw today, are excited to continue their families, but they are scared, and so are physicians. I've reviewed the regulation, and in my professional opinion, y'all, they are not workable. It will only make my life as a physician feel more defensive and less certain of what they can and cannot do in emergency medical situations. The documentation requirements in particular will make my job, which let me tell you is already severely complicated because of these Texas abortion laws, nearly impossible. The documentation required is excessive, and it goes far beyond what is ordinarily documented in a patient's file. And regardless of when I do the paperwork, these proposed rules require me to consider many burdensome, and in many cases, impossible alternatives to abortion, all while leaving my patient's life at risk. And I know this has been said over and over again today, but it's true, okay? Find me another medical procedure that requires this much documentation. I'll wait. The problem is these rules proposed are biased, and they assume that abortion is wrong and should not be required or offered to patients. And that is just the flat out truth. They're biased. These are not hypothetical situations that we've all talked about. We've had doctors and patients on here today talking about their experiences. I don't want to be redundant, but I can just tell you that I disagree on what is going on and what the proposed regulations are, because they are just making it harder and harder for us to take care of our patients whom we love. Patients that we want to be able to have new pregnancies and continue their families and to remain safe. Thank you.
Appreciate your comments and your feedback. Okay, Steve Wallop.
Can you hear me okay?
Yes, we can. Go ahead.
Okay, very good. Thank you. And thank you very much for the opportunity to speak to you all today. I'm Steve Wallop. I'm the General Counsel of the Texas Hospital Association, and I'm here representing our over 460 hospital and hospital system with this opportunity to speak to you directly. We do certainly appreciate the Texas Medical Board and the staff's commitment to the rulemaking process that we hope will result in the improvement of the safe and legal delivery of healthcare to Texas women. We submitted written comments last Friday and don't intend to repeat all of those points we raised in our letter here today. The Dobbs decision in the Texas Trigger Law, Health and Safety Code, Chapter 170A, that went into effect roughly 2 months after the opinion was issued, drastically changed the regulatory framework governing abortions in Texas. I think we all understand that. But even before the Trigger Law went into effect, the dynamic between physicians, who are the only individuals permitted by law to make the medical judgments necessary to determine whether an emergency abortion is permitted, and the hospitals where those medically necessary abortions are carried out, became strained. There were unresolved questions about what law was even in effect, and the state of the law and how the various laws on the books, both old and new, were to be interpreted was largely untested. And of course, the stakes became much higher. And at the time, many hospitals were without an infrastructure or process for working with physicians to help resolve complicated questions of whether those cases met the statutory exceptions permitting a medically necessary abortion to be performed. Prior to the Dobbs decision, only 0.01% of abortions were being performed in hospitals, so the impact was profound. This led to tense situations when a pregnant woman presented to a hospital and the medical standard of care dictated that a medically necessary abortion be presented as a treatment option. And while we were never able to substantiate some of the claims that were made about hospitals impermissibly interfering with the practice of medicine in those cases, it's certainly conceivable that there were disagreements about whether an abortion was permitted under a specific set of circumstances within the governing statutory language for all the reasons I just mentioned. The difficulty physicians have had and still have with applying the various and disparate Texas laws to specific clinical circumstances has been discussed at length when the rules were presented in March and today. We do think the Texas Medical Board, not hospitals and not industry representatives, but the Texas Medical Board is uniquely situated to help resolve some of those questions by giving guidance to its licensees on acceptable practices within the statutory framework that the legislature has given them. We think the rules as proposed, however, will not advance that aim, and in some respects that we detailed in our letter may do more harm than good. The difficult judgments physicians must make in applying a high stakes laws to complicated clinical situations requires at a minimum clarity in the law. Texas physicians and Texas women deserve no less. We have given the board suggestions and know that the board has received input from many knowledgeable resources on how the TMB rulemaking process can lend clarity to these difficult situations and improve outcomes for Texas women within the policy mandates handed down by our legislature. Thank you.
You appreciate your comments and your written comments you presented as well. Dr. Safran, any questions or you may have?
No, I appreciate also the fact that you stated very clearly that physicians should be the ones that ultimately make the decision as to whether a procedure will move forward or not. I think hospitals certainly have a place to help with guidance. I know there was a lot of confusion and concerns at the very beginning when the law first came out, and I think that may have led to circumstances that were unforeseen, especially those who were asked to leave and came back in septic shock several days later. I'm hoping that there's a lot more clarity around that today, that imminence is not something that has to be looked at as far as making sure that a patient gets treated. And if we need to further clarify that more, we will look at being able to do so. So thank you for your comments.
That was actually one of the specific points we raised in our letter, Dr. Zafran, and thank you for that. I do think the situation has improved vastly in terms of the cooperation that happens within a hospital when these sort of dire circumstances are playing out. But I do think that the law is still really lacks the clarity as it has in the beginning, and that's of course why we're all here today.
Daniel?
Hey, can you hear me okay?
Yes, we can.
Okay,
Good
sorry
afternoon.
about my camera not working after I've been hanging with you all day. And thank
That's
you
okay.
for the thanks for the opportunity to submit written comments and provide additional color. My name is Katie Daniel. I'm the State Policy Director for Susan B. Anthony Pro-Life America, a national network of more than 1 million pro-life Americans. In addition to the proposed rules, we recommend that the TMB creates a landing page similar to the COVID-19 page. First, this could state which laws apply to physicians in various contexts. As an example, a physician who treats an abortion complication in the emergency room but did not perform the procedure is required to file the abortion complication report, while a physician who performs an abortion under the medical emergency exception would be required to file a medical emergency abortion incident report. If complications arose during that procedure, however, the physician would be obligated to complete both of these reports. Linking these documents and providing additional information on a TMB landing page would make it easy for busy physicians to obtain the information, bookmark the page, and increase compliance, leading to fewer complaints to the TMB. This page would provide you with the flexibility to inform the profession and the public on an ongoing basis. We recommend that the TMB also issue a recommendation to hospitals that they evaluate their existing protocols and recirculate them to employees and affiliated doctors. Most physicians don't perform elective induced abortions, and most facilities don't provide them. What hospitals are likely to find is that they don't need changes, as they already were not performing abortions, and what is permitted under the exceptions now does not differ from what was permitted under the exceptions before Dobbs. I've heard from physicians in Texas and elsewhere that this process is helpful to them because it confirms that their practice did not change when the pro-life laws took effect. And for those who were performing or referring for elective induced abortions that are now unlawful, this review can assist them in understanding the law and best practices, which is something that's obviously of interest to the TMB. The TMB should also use the rulemaking process as an opportunity to remind physicians that Texas has made an intentional decision to protect life and make sure that physicians know about the resources available to their patients. Too often, we hear stories of families receiving a fetal diagnosis and being told, "There's nothing I can do for you, you need to abort." If this story takes place in Texas, women are told to drive to Colorado or New Mexico or fly to DC or New York. This is not because life-affirming and life-honoring options don't exist, but because abortion has become the default for a variety of diagnoses, both lethal and non-lethal, whether accurate or inaccurate. There is another way, though. Take Dr. Elvira Paravicini, who directs the neonatal comfort care program at Columbia University. When families are told that there's nothing for them because many New York City doctors default to abortion, Dr. Paravicini offers dignity, options, and healing. Her team's patient care guidelines are available free of charge online, and this is exactly the kind of resource the TMB can include in this landing page. My cousin was born with hypoplastic left heart syndrome 9 weeks after me. He had multiple open heart surgeries in the months after his birth. This is exactly the kind of diagnosis that puts parents under enormous pressure to abort from the very people they expect to help them. HLHS used to be a death sentence. Now the outcomes are much better if you can make it down the birth canal. This is because there are physicians and families striving to improve the treatments available. Texas has made a decision to fight for these children and their parents by protecting them in law. The TMB should help these families and their doctors by sharing information about the resources available both in Texas and nationally. You might be wondering what happened to my cousin. He is now a husband, a father, and a board-certified pediatrician treating patients in Houston. SBA is grateful for the opportunity to join this process and improve the practice of medicine for Texas women and children, and I'm happy to take your questions.
Thank you for your comments. Dr. Zafran, you think?
No, as always, thank you for your comments. There's a lot of helpful suggestions there, and some of these things that we can take to heart. I know that we are looking again at FAQs once we have a final rule, whenever that might be. But those are certainly very helpful suggestions.
Yeah, absolutely. We look forward to helping with the FAQ process and did provide some suggestions in writing of questions that you might include in that.
Thank you so much.
Thanks.
Luis Joy.
Hi, I'm Louise Choi. I'm a healthcare attorney who has practiced in Texas and was in Texas starting in 1985 in hospital administration. I've represented healthcare institutions across the state and across the country since 1991. Looking at these abortion laws and the rules that you've come up with, I think we should put Texas in perspective of the country. We have 6.3 million women of childbearing years in Texas. We have then some of the highest possible incidences of these rare occurrences that need doctors to have more assurity that when they're making a decision, they don't have to think through a lot of steps if they've identified the problems that you have heard many of the women who talked with us today. And you've said things that should cause them to have assurance that they could proceed with life-saving care that would save their future reproductive health, save them from other consequences that might come from these pregnancy-related emergencies. One of the things that's hanging over each of these doctors is you've got the risk of the loss of the license. Yes, you've got control of that. There's also at least $100,000 fine if they're found in violation, which is not in your jurisdiction. There is the bounty cases, no less than $10,000 plus attorney's fees. And then 5 years to life in prison if they're found in violation. So while the medical board doesn't have mandatory authority over what happens in the criminal matter or other courts, you do over your licensing. You do have persuasive authority. So if your rules would only give doctors more assurance, or at least guidance, that some of the things that we've talked about today are things they don't have to spend a lot of time thinking about and wondering, am I going to be in violation of any of these? No lawyer could tell somebody for sure, absence very extreme circumstances. When you're at the risk end of things, how can any lawyer confirm that the doctor is not going to face these consequences? But if the medical board would speak out on them, it would help. So one of the things that I even heard today, Mr. Carlton said that he didn't think that the selective reduction provision under the definition of abortion would apply in the case of Lauren Miller or Sarah Harrison. I would disagree with you, but let the medical board help us there. If one of the pregnancies in a multiple pregnancy is going to risk both the other pregnant, the rest of the pregnancy or the life of the mother, then that should be allowed. I thought that exception applied until I heard you, but that's the very confusion that we have. And then when it goes to mandating how the documentation of how you prevented harm or sought to save the life of the child, you haven't, it's not mandated that that be documented. It's mandated that it be done unless there's an issue with the life of the mother. And that your provision under the proposed rules does not even address the fact that that wouldn't have to be done if there was a concern about the life or health of the woman on which this was being performed. Thank you.
Yes, thank you for your comments. Okay, Reagan Stone.
Hello, good afternoon. Can you all hear me?
Yes, we can. Good afternoon.
Hi, good afternoon, commissioners. My name is Council Member Reagan Stone from Alpine in the Big Bend region of Texas. Apologize, I'm having a little lunch here, but thank you for allowing me time to give testimony. I'd like to note my strong personal opposition to the near total abortion ban, as well as to the rule changes as they are laid out. These laws have stripped the people of Texas of their rights to medical care, confidentiality, and legalize cruel and unreasonable punishment. These laws have also stripped Texas doctors and their ability to provide life-saving treatment before a routine, safe treatment was banned. That was an abortion procedure. I do appreciate each of you attempting to push back a draconian statute that we only thought was possible in TV shows until a few weeks ago. However, like the horrid TV show you might know I'm referring to, there's no accountability here either. And a rule that was in large part, it will affect Texas women and their reproductive rights. I'm deeply disappointed to see 3 men who cannot be forced to carry or who will never suffer from what we are speaking of today up here with their cameras on, with very few board members present. There appears to be no quorum, no regular rules that were shared with the public, and even our time allotment was changed from what was said before. As far as we know, we have more lawyers than doctors on the call representing the state today. I'm sure board members have day jobs. The public does too. Leading more to my point, and since this is now a legal discussion, and the board truthfully is being dragged into a political decision, I'll keep it simple. And first, just give some basic facts to share what life is like in rural Texas. In my district, we are far from medical care. Even regular doctor's appointments can take 2 to 3 hour drives, and in an emergency, as we're talking about today, air transport or a $50,000 bill is the only way out. But this is only exacerbated in alpine or rural settings. Texas has a medical, health, and insurance problem, or lack thereof. With limited access and unaffordable bills, these rules will further bankrupt families or cost the state millions of dollars because hospitals, medical districts, and rural providers will not see the incentive to have facilities or specialists out here, or in many other parts of the state, when a procedure that is medically necessary is practically illegal. And sadly, that point's about money. Now, a lot of y'all know, and we all have a lot of legal and medical background folks that are testifying here, and they're telling y'all the same thing. We need specifics on when an abortion is allowed. I mean, imagine being in a room with loud sirens, doctors and nurses' orders being given, blood, a life on the line, and now one's livelihood on the line too. Doctor and patient simultaneously being threatened. Why not make sure your rules are as clear as possible so that person on the table has the best chance to survive? 2, we need protections for doctors and patients. I bet y'all know a doctor, and I bet y'all also know someone who has had a safe abortion. Respectfully, don't be part of the criminalizing theater. And this is part of a larger issue. We have an increasing maternal mortality and teen pregnancy rate. 2 things I don't think you or Texas should be proud of. 3, y'all have a court case. The Zuwarski case gave you a legal and medical ruling that was already agreed to by the stakeholders. The only stakeholder that I know didn't agree was the Texas AG, and y'all alluded he broke the law in giving medical advice in real time. With that said, I ask that you not bring politics into this. You as lawyers or doctors have made an oath to the truth or to your patients. Please work with these stakeholders and your expanded stakeholders, that is the people of Texas. Mr. Carlton, Dr. Zaffron, Mr. Fresshouse. The rock and hard place analogy doesn't work here. It's life or death. Thank you again for your service, and I'd be happy to answer any questions.
Mr. Stone, for your comments. Appreciate your feedback. Okay. Holly Cunningham. Holly, are you with us? Oh, I can see you now.
Oh, yeah, I do see them in the meeting, and they have mic and camera ability. You will need to unmute on your end.
We can see your hand up, Holly.
If you are able to unmute, perhaps you can leave the meeting and come back, and Mr. Carlton, if you would like to move on to the next person in the meantime.
Yeah, we'll come back to you. Tatum Owens.
Hello, can y'all see me? My Wi-Fi was
Yes, we can see you and hear you. Yes, good afternoon.
Good afternoon. It's funny when I wrote this, it was good morning, but good afternoon. My name is Tatum Owens, and I'm a young Texan of reproductive age living in Brazos County with fewer rights today than when I was born. On behalf of Progress Texas and myself, I'm commenting in opposition to Rule 165 today because I, like many others, feel that it failed to deliver a sense of clarity and guidance for medical practitioners across the state regarding what constitutes a medical emergency as an exception to Texas ordinance. This is deeply troubling to me because I need my doctor to feel empowered to do what's best for me and required for my health and well-being. Can't do that as the law lays and without your help paving the road to healthcare access. Sorry, excuse me. So sorry about this. I've heard some other sniffles on the call today. What I really want is those who can become pregnant and already pregnant Texans across the state to have access to equitable and accommodating healthcare, but that's not the case. So I'll settle for you taking up the responsibility punted to you by our lawmakers and courts to ensure everyone's doctor can practice reproductive medicine without retaliation and save our lives. Our lawmakers surely won't. And unfortunately, we aren't empowered as patients, so it's up to you. Forced pregnancy in threatening situations is not an American or Texan value. I graduated college last year, and my community are constantly debating about how we love our state, but it doesn't love us back. Some want to leave out of fear that there will be even more restrictions. Others rightly can't afford a pregnancy, wanted or unwanted. Like me, I literally cannot fathom being a mother where I am right now, and it's my choice when and if I begin a family. And like Reagan mentioned, the rest return to maternal health deserts where their lives would be threatened if a medical emergency presented itself, like they very often do because pregnancy is full of complications, and they could die like Jennifer Alvarez Estrada Glick, only 6 years older than me, who died only 2 weeks after Roe's overturn. I think about her a lot, and the only reason she isn't here today is because of fear around administering reproductive health care. Her many medical conditions constituted a high-risk pregnancy, and yet out of 5 visits with her doctors, she was never presented with the option to an abortion. There will only be more people like her if guidance for doctors isn't issued, and I don't want to witness any more unnecessary deaths. Inaction cannot be accepted with Texan lives in jeopardy. So we need clarity now on what the Texas Medical Board views, and we've heard this before, but I'll give you my list, as medical emergencies, so doctors and patients can freely navigate access to reproductive health care. As it is currently, the definition is extremely broad with no mention of the long list of conditions that complicate pregnancies and endanger lives. Your prompt action will save lives and futures. Please adopt rules that clarify the following. Clarify that the medical emergency exception to the abortion bans applies where pregnancy places the woman in danger of either death or a serious risk of substantial impairment of the major bodily function. Key terms such as serious risk and substantial impairment need to be clearly defined as used in Chapter 171 of the Texas Health and Safety Code. The board should also clarify that a physician can provide an abortion as soon as they identify these dangers and without waiting until life-threatening symptoms manifest. This must include already established judicial interpretations to help doctors make informed decisions when providing emergency care, especially regarding the inclusion of care for imminent death, we've heard this, and doctors' reasonable medical judgment. For example, recent Texas Supreme Court rulings regarding the definition of medical emergency should be incorporated to ensure accurate understanding and application by doctors. I object to the wording of proposed section 165.8A because it is likely to deter rather than foster physicians from providing standard of care abortions in medical emergencies. Physicians are already being deterred from providing such care due to the threats of criminal prosecution, up to life imprisonment, massive civil penalties, and the loss of license. Section 165.8B imposes excessive documentation burdens on doctors who provide medical emergency abortions, quote, medical emergency abortions. These requirements hinder standard medical care and complicate and delay critical care for pregnant individuals, as we've seen today. State health physicians can ensure their medical judgments meet the standard for reasonable medical judgment required for medical emergency exception. I'm almost done. Provide the level of detail and legally sufficient evidence that must be present to substantiate a claim that an abortion was not protected by a medical emergency exception. Physicians face the loss of their medical license, life imprisonment, and more than $100,000 in civil fines for providing necessary care. They need clarity regarding how and when their medical judgment will be respected before they feel comfortable relying on the medical exception as the legislature intended. As written, the proposed rules do nothing to provide physicians with reassurance that their judgment will not be second-guessed. Please review these additions, and thank you for your commitment to protecting Texan lives. Thank you.
Thank you, Tatum. We appreciate your comments and you taking the time to be here today. Okay. Try Holly Cunningham again.
Can you hear me?
Yes, we can.
Okay, I was having difficulty with my computer. Let me get my video on. Can y'all hear me and see me?
Yes, we can hear you and see you.
Okay, there we go. Thanks for coming back. Hi, my name is Holly Cunningham, and I'm here today to share the deeply personal impact that abortion bans have had on my family. As a proud Texan of 24 years, I have experienced firsthand the devastating consequences of restrictive abortion laws. I'm determined to advocate for recognizing abortion as essential health care, especially in cases involving anencephaly and other fatal diagnoses. In 2023, my husband and I had to terminate 2 pregnancies due to a 100% fatal diagnosis. Both times we learned that our babies had anencephaly, a condition where they had no brain and would not survive outside the womb. Living in Texas, where abortion laws have become increasingly restrictive, only added to our burden. We felt trapped as if our options were being taken away by politicians who couldn't possibly understand our pain. We are deeply disappointed with the Texas Medical Board for failing to clarify the medical exception in Texas abortion bans. This lack of guidance leaves doctors and patients in a dangerous, uncertain position. In January of 2022, we discovered we were pregnant, but by March, our excitement turned to sorrow when we learned at the 12-week mark that our baby's heart had stopped beating. Under the care of my trusted doctor, I underwent a DNC procedure. Further tests revealed a rare and fatal disorder, trisomy 20. I was able to receive the necessary health care in Texas because the baby's heart had already stopped. That fall, we were expecting a baby girl, a dream come true for our family. However, our joy was shattered at the 20-week anatomy scan in January of 2023, when we learned that our baby had anencephaly. Texas regulations restrained our doctor from providing any direction, leaving us to make a heartbreaking decision despite significant risks to my health. We quickly located a state capable of offering essential health care, arranged childcare for our 2 boys, and made travel arrangements. Abandoning our support system in Texas was incredibly difficult. The clinic prohibited my husband from accompanying me. I underwent the most traumatic 2-day experience of my life alone. We bore the financial burden ourselves, spending thousands of dollars. We said our goodbyes to our daughter, Ellie Grace, and flew back home with empty arms. Explaining her passing to our 2 boys was heart-wrenching. 4 months later, we sought advice from an IVF doctor, given our past experiences with 2 rare and fatal disorders. After a successful egg retrieval, our first transfer was successful. But at the 13-week appointment, we received the devastating news again. Our baby girl had anencephaly. Once again, we had to seek healthcare outside Texas, reliving the traumatic experience in December of 2023. We said goodbye to our 2nd daughter, Lily Grace. Complications followed, leading to another surgery this February. In 2023, I faced the most difficult year of my life, with 2 necessary medical abortions. This experience has left lasting scars, and I'm still currently searching for the right counselor. The overwhelming emotions of anger and sadness stem from the fact that my home state couldn't provide the necessary assistance, forcing me into another traumatic situation. It's shattering that decisions about women's bodies are made by male politicians who lack understanding of the difficulties involved. Abortion bans do not protect life. They only cause further harm to those already suffering. They force families like mine into impossible situations, navigating a maze of legal restrictions to access the care we need. The trauma of having to say goodbye to our babies before we ever had the chance to meet them will stay with us forever. The knowledge that our own government would deny us the right to make decisions about our own bodies only adds insult to injury. I share our story to highlight the real-world consequences of these laws. No one should have to endure what we have been through, yet countless of families continue to suffer because of the outdated and harmful policies. It's time for change. It's time for compassion. It's time to trust women to make the decisions that are best for themselves and their families. Until then, we will continue to fight for the rights and dignity of all people in similar circumstances. The Texas Medical Board must step up and provide clear and decisive guidelines to protect both patients and doctors in these critical situations. Thank you for your time.
Thank you for being here and for your comments, for sharing your story. And we're sorry for all the complications and difficulty and trauma that you've been through. And again, it says a lot for you to take the time to be here and make your comments to us today.
Thank you very much.
Okay, the last one that is signed up on our list is Judy Levison. Let's see, Judy, are you able to hear us?
I see a Judy signed into the meeting, and they've been trying to access my mic and camera. I do see a Scott Simpson raising their hand. It's possible that they're affiliated.
Yeah, I don't know if Scott is there for Judy or is just wanting to speak also. What we are going to do is once we get through Judy, if she's able to talk, or once we, I guess, get through the list here, then we will start taking people in order that they raise their hand if they had not been on the list and are still wanting to take the opportunity to speak. So since
Yeah,
we're not
this
hearing
is
anything from,
this is Scott Simpson. Can you hear me?
yes, we can hear you.
So let's see. I thought I would be on the list from my written comments, but that I submitted weeks ago. Perhaps something happened. Before I start, just for clarification on Ms. Harrison's testimony, where she was talking about the fetal reduction. I thought I heard her say that baby B had a heartbeat and was alive, and that's why it fell under the abortion. I don't think that child was a demise at the time, but I could have been wrong. So my name is Scott Simpson, and I'm providing public comment as an individual in opposition to the adoption of the new rules. I've provided written comment as well, but I hope you got them. I'm a retired OB-GYN physician and medical administrator, educated and trained in Texas, and a licensee of this board for the past 45 years. I'm providing comment on behalf of my 3 granddaughters and myself, and in support of the brave women who testified before you in March, and many of the same and more brave women who testified before you today, and in support of the women who have sued the state of Texas over abortion restrictions, and all of those Texas women who are or will become pregnant in the future. I'm also providing comment in support of the well-trained and thoughtful Texas physicians who provide care for these women. Should one of my granddaughters become pregnant, and should she have a pregnancy complication, I would want her to have access to at least the same evidence-based care that my wife and daughters had access to when they were pregnant. I would want her physician to be able to provide timely, necessary, and compassionate care based upon her physician's medical expertise and judgment. I would not want her physician's decision-making to be compromised by an oppressive threat of felony conviction based upon overly restrictive and vague legislative language. Unfortunately, our state legislators have put us in the position where my granddaughter may well not be able to receive, and her physician may well not be able to provide the medically indicated care that she was trained over many years to provide. The Texas legislature has created, through its abortion ban, a significant public health hazard when it should be acting to protect public health. This has caused and will continue to cause real harm to many Texas women and physicians. It is sad, cruel, and in the end, self-defeating. Although I appreciate your efforts in advancing these surrounding interpretation of the state's abortion ban and exceptions, nor the catastrophic felony threat to physicians, nor the tragic situation of women who have been raped, subject to incest, or are pregnant with a fetus with a significant congenital anomaly. The problem is the law, the abortion ban's legislative language. Rule modifications may ease the problem, but I doubt they can completely resolve it. After critically examining the situation, I hope you will conclude that the Texas abortion ban statutes themselves are significantly flawed and cause clinical harm. As such, I would like to suggest that you communicate your concern for the welfare of pregnant women and their physicians to the legislature and the governor. I have offered suggested language modifications to Chapter 170A in my written comments. I realize that you don't write the laws, but based upon what you've heard today, I would hope that you realize the magnitude of the problem, pregnant ladies and their physicians are having in this state today. And I hope you would be moved and be wise enough to suggest to the folks that can change the law of the problems that the existing law is causing. I really want my granddaughters to grow up in a better Texas, not this one. I'd be happy to answer any questions, and if you all form any working groups to flesh this out better, I'd be happy to be involved.
We certainly appreciate your input today and your time as a physician. You know, it's as part of the rulemaking process, as I'm sure you're well aware, but you know, just kind of a reminder for everyone else on the call today. After taking the feedback, both written and the oral comments, and I'm sure we do have your written feedback, and we've received quite a bit. Whenever we go through all that, you know, assuming that there are substantive changes made to the rule, then we'll have to kind of go back to square one of putting a new proposed rule out there and starting the process over again of receiving new comments, potentially having another stakeholder meeting and kind of going through this again. So it's not necessarily something that might go, you know, really quickly as we continue to get feedback from everybody, but we certainly appreciate your participation and the comments you provided with suggestions on your thoughts on how to improve the rule.
I appreciate your letting me speak, and all I can say is please listen to the affected women and listen to the affected doctors. They are powerful stories that are genuine and real, and the problems are real despite your intent.
Thank you. Appreciate your time. Okay, next we have George-Ann Freeman. Dr. Freeman, can you hear us?
I can hear you.
Now we can. Yep,
Okay.
We can hear you now. Yep.
Okay, great. Thanks. I won't belabor points that have already been made, but I do agree with one of the men earlier. And I don't know if it's in y'all's purview to change the language to be more medical, which would be referring to a fetus, which is what's carried in the uterus, as opposed to the unborn child. I think it just further politicizes this medical situation. Curious about that.
No, I hear your question and you know, and your concern in it. What we did is we just took what was already in the statute and put that into the language of the rule to keep consistency.
So is it within your purview to make that a more medically appropriate term, fetus, rather than unborn child, or y'all don't have that ability to make that correction and then be more consistent with the actual medical term?
It's something that we can talk about as staff, but again, we generally try our best to keep terminology the same from statute to rule, so there's not a disconnect between the two. But I do hear what you're saying.
Especially because it is a more appropriate medical term. And again, I understand that lawyers created this rule, really not doctors, but it would be more accurate medically to be consistent referring to this as a fetus rather than the unborn child. And maybe it could go back.
I could chime in. So the medical board gave staff direction to utilize the language in the statutes directly. And that kind of keeps us out of trouble because we have to be very careful about making sure that we're following the letter of the language of the statutes itself. A lot of times we don't necessarily write rules when the statute is there because the statute's language is the statute's language. What we're attempting to do over here is take a collection of the different statutes that apply here and put that language specifically in one rule. And, you know, we can't take a statutory language and then arbitrarily change the language as we're putting it in this rule. So those are the constraints that we're faced with. When we talk about elaborating and clarifying and establishing what a statutory language involves us doing as far as enforcing it or clarifying it, that's where we have some discretion. But where we're taking the actual language itself, we don't have that much discretion in there because we are referring back to the language. And as you are aware, you know, language can be interpreted in many different ways. And to keep ourselves out of legal trouble, we're using the actual statutory language itself. So that's direction that the board itself gave to staff as we put the language of the rule together.
And to expand on that just a little more, like for example, in one's health and safety code 170A, it does give a definition of an unborn child. And so again, it's following through with, okay, that's the phrase that they're using in this context. And so that's what's following through from statute to rule. And then it tells you what the definition of an unborn child is.
Alrighty.
Yeah. Any other comments or anything else that you have for us to take under consideration?
Nope, thank you.
Okay, thank you very much. All right, next is, I don't see a name, but the hand is raised for Texas Right to Life.
Yes, hi. Can y'all hear and see me?
Yes, we can.
Okay,
good afternoon.
perfect. Good afternoon. My name is Miranda Wilborg, and I apologize. We received confirmation we were on the list, but I think my name specifically was not submitted, so I'm sorry for the confusion on that. But my name is Miranda Wilborg, and I serve as the paralegal for Texas Right to Life. And Dr. Zafran and members of the board, thank you so much for this time to give public comment. Thank you all for your diligence in crafting these proposed rules guiding physicians regarding abortion and the medical emergency definition in Texas law. Texas's pro-life laws are clear that if a pregnant woman is facing a medical emergency threatening her life or a major bodily function, she does not need to be at death's door for a physician to act in treating her. And while this law is not new, implementation has proven problematic since Roe v. Wade was overturned and Texas law outlawed elective abortion from the moment of fertilization. And this confusion is unnecessarily putting women's lives at risk. So we are pleased and grateful that the Texas Medical Board is assisting in dispelling the confusion with these rules. While overall Texas Right to Life is pleased with the proposed rules, there are just a few aspects that we would like to give input on before the Texas Medical Board finalizes them. The first is that we would encourage you to maintain the way the proposed rules reaffirm current statutes, showing adherence to Texas law and showing that you have chosen not to create an explicit list of circumstances that fall under the medical emergency definition, besides those already listed in statute, but rather defer to physicians' reasonable medical judgment. We also appreciate how the proposed rules do not encompass a preborn child's life-limiting disability as falling under the medical emergency definition. These circumstances are tragic, and Texas can and should prioritize life-affirming policy options, helping these children and their mothers and their families through such situations, including perinatal palliative care. But Texas law does not consider a child's disability as qualifying for abortion under the medical emergency definition, and neither should these rules. One important way we would like to see the proposed rules strengthened is, as several people have already mentioned, by clarifying the fact that imminence is not required for a physician to act when he or she can foresee a threat to a pregnant woman's life or major bodily function. Women do not need to be at death's door for a physician to take action. Nothing in any of our pro-life laws states or implies that a pregnant woman must be actively dying before medical professionals can intervene or for the situation to qualify as a medical emergency. The statute does not demand this, but this misunderstanding has put Texas women's lives in jeopardy unnecessarily, and we believe must be clearly stated to avoid further harm. We have submitted written comments as well, and we look forward to seeing what finalized action that the Texas Medical Board takes. So thank you all so much for holding this stakeholder meeting and for your consideration of our comments and for your service to our state as well.
Thank you for your comments and feedback and suggestions on our rule.
Absolutely, thank you.
Okay, so a few more hands up. Next one up is a phone number ending in 9021. Well, and the hand just went down.
Can you hear me?
Yes, we can.
Okay. My name is Judy Levison, and I apologize. I was unable to unmute on Teams.
Oh, hey, we're glad to have you.
Okay. I'm an obstetrician gynecologist and a plaintiff in Zarowski versus the state of Texas. The Texas Medical Board is in a very difficult position. I respect your attempt to clarify the current Texas abortion laws, but how can any group clarify laws that many clinicians find inhumane and unethical? I strongly oppose the current rulemaking because it fails to resolve the confusion for OBGYNs practicing medicine under Texas abortion bans, and I wish to make 2 points. First, Texas Medical Board's proposed rule still does not explain when an exception is warranted and an abortion may lawfully be performed. That's what this exercise should be all about. I think the examples given by Lauren Miller and Sarah Harrison are excellent examples of how mothers and remaining babies are put at risk if fetal reduction cannot be done. Second, the proposed rule says that the physician must specifically document in the patient's medical record that an abortion was done to prevent, and the wording in your rulemaking is to prevent a serious risk of substantial impairment of a major bodily function unless the abortion is performed or induced. If only the current Texas law allowed abortion to prevent a serious risk of substantial impairment, I might feel like we're taking a step toward ethical health care, but that's not the wording that is in the law. An example, for the pregnant woman diagnosed with a cancer for which she cannot receive first-line chemotherapy while pregnant, abortion is health care. But the way the rule is written, these women may not have medical emergencies, emergency implying risk of imminent damage, death, and still cannot obtain an abortion when needed. And additionally, under the new documentation rules, would doctors need to now determine if they can transfer the cancer patient out of state for an abortion before offering the one in state? So my question is, again, related to imminence, which has been a theme today. What do you do with someone with cancer? You delay her treatment, and she may not be there in a few years for her family. So I'm hoping that the board will realize that there still are many circumstances that are not covered. Thanks.
Doctor, thank you for.
Yeah, go ahead, Dr. Saffer.
Yeah, thank you for testifying. I just want to, again, I know this theme has been coming up, but when we talk about risk of permanent bodily injury, and again, we're not talking about imminence, and again, we can have a conversation about how we can make sure that that is a lot more clear. But it would seem to me that somebody having cancer, and especially if it's a type of cancer that if not treated would progress to, or would have a high probability of progressing to permanent harm. I mean, again, I'm not sure if I'm just not, if I'm seeing something that everybody isn't seeing, but to me, that sounds like something that would fall under an exception. And so I don't know if it's just that we're not making it clear enough in our rules, although I think every attempt was made to be able to do so. But again, whether the permanent harm would happen now, or whether the permanent harm would happen later, but the intervention can only happen now, for example, chemotherapy, radiotherapy, whatever that might be. And at that point, the choice, the mother's choice would be to either, take the radiotherapy and the chemotherapy or not take the radiotherapy and chemotherapy. I think there was an example recently of somebody deciding not to and proceeding to have the baby and unfortunately the mother, didn't make it afterwards, but that was a choice that she made. But again, going back to the theme that I just said, and I'm hoping that it's clear enough, and if it's not, we'll try to help clarify that. But permanent damage does not have to be imminent. And if the treatment to prevent that type of permanent damage is now, to prevent the permanent damage that would be, say, a year from now, I believe that still falls under the exception. It would just need to be documented that way. So I hope that's clear. And again, if it's not, we'll look at and see how we can try to make it more clear. But I just want to make sure that for everybody listening, that is our intent.
And I'm thrilled that that's your intent, but that's not the way the law is worded.
We can certainly take a look at possible alternative language to make the board's intent more apparent.
Thank you.
Yes, thank you. Okay, we still have 3 hands up. Next one is Rachel Gearing.
I'm an attorney at Weaver Johnson Nelson. I'm a healthcare attorney at one of the largest healthcare firms in the state. I just want to say I appreciate what the board is trying to do here, and I appreciate the limitations. I understand that the Texas Medical Board is not able to rewrite this statute. It cannot make carve-outs that it may want to, for example, for non-viable fetuses and things like that. And I do understand that you are limited in interpreting the statute, and I fully respect that. First, I wanted to discuss the physician documentation requirement in section 165.8, and I don't want to beat a dead horse here. I know, Dr. Zaffron, you've been very clear that it is not the intent of the Texas Medical Board to make this an exhaustive list of items that need to be addressed in the medical record, in particular with many other speakers have discussed subsection 7 that requires the physician to document whether there was adequate time to transfer the patient to a different individual with different expertise. But the text of that section actually does objectively read as an exhaustive list that where each item needs to be addressed. And I understand that's not the intent. So I expect that the TMB will revise that and use and/or statements in there, or if applicable, statements, language to change it, because again, I know you've said the intent is not that every single one of your subsection 7 needs to be addressed in the medical record, but as currently written, just as a lawyer, it actually does require that each of those is addressed with the language. The physician must specifically document in the patient's medical record. And as I said, at the end of each subsection is an and not an and or an if applicable. So that's the first thing I'm going to say. This and I want to acknowledge Amanda Zarowski. They make great points, and I think pretty much everyone who has spoken up, with the exception of the Right to Life groups, has said the same thing, that I think physicians may not necessarily feel empowered, that their reasonable medical judgment is what is going to be the determining factor in the end of the day. If there's a political witch hunt or a suit that's filed or a complaint against that physician. And I think the Texas Supreme Court in the Cox case was actually pretty clear. And they said, if a doctor using her reasonable medical judgment decides that a pregnant woman has such a condition, then the exception applies and Texas law does not prohibit the abortion. And I think we should take that language for what it means. And if the individual in their reasonable judgment, and I think what you've heard from Ms. Cox and others was that their physicians were told by hospital administrators, ethics committees, that they were just too unsure. And of course, you also brought up the corporate practice of medicine, and Texas is a corporate practice of medicine state. So it should be a little bit, I understand that hospitals are trying to protect themselves. As a lawyer, I'd probably do the same, but I think what we should do is really empower physicians and let them know that the Texas Medical Board trust their decision making, and obviously absent cause showing bad faith on behalf of the physician, that their reasonable medical judgment will prevail. And in my comments, I proposed a couple ways in which we could do that. I think first and foremost would be kind of a safe harbor where a physician would get maybe 2 other board certified physicians who agree with their reasonable medical judgment that the situation necessitates an abortion. That I think will my proposal would be that the absent showing, clear and present evidence of bad faith on behalf of the physician, that physician's reasonable medical judgment will be trusted and complaints against that physician would be dismissed. Again, I don't believe that it is necessary to have 2 board certified physicians sign off on the reasonable medical judgment, but I do think that should be a safe harbor, that if in the event prior to performing the abortion or immediately near after, as accordance with the medical record rules, if a physician has 2 board certified physicians who agree with their medical judgment, any cases against them would be dismissed, and that physician we would honor their reasonable medical judgment. I think that puts this back in the hands of physicians, shows that the Texas Medical Board trusts and believes physicians, and that they are empowered to do what they need to do on behalf of their patients. And I think that fits in with the board's goals as well as the Texas Supreme Court.
So first of all, for your comments, and you made a lot of very good comments. And what I would say is we kind of already do that, except we use our own expert panelists who are 2 board certified physicians who are licensed in Texas, who are not in the same geographic area, but in the same type of demographic. Again, that's a statutory mechanism to adjudicate what the standard of care is. That's why in our rules, we've kind of delineated the normal type of things that we look at from the standpoint of what the standard of care is, which is what a prudent physician in a similar circumstance, in a similar type of setting, would also do. And that's what we were trying to highlight, whether it's from the medical record keeping, again, understanding that it's not supposed to be an exhaustive list, and we can look at that. But again, what you're suggesting is reasonable, except we're doing it because you don't want it to be 2 physicians who are in the same group, for example. You want to make sure that there is an independent source of physicians who are looking at it. But again, the expert panelists that we use are independent physicians. They don't work for the board. They are in that board. They're in that same specialty, and they're licensed in Texas. So we're presuming that because of that, they are all looking at it from the standard of care. And in fact, we use 2 from the standpoint of looking and reviewing it. And then if there's a tie between the 2, then we actually look at a third. And we as a board, if those 2 physicians say that the standard of care was met, we as a medical board can't go and say, no, the standard of care wasn't met. We're actually bound by that, at least from the standpoint of standard of care. My general counsel is looking at me, making sure that I say the right thing. And I think I am. Actually, I'm sure I am. But the point is that we do utilize that mechanism. I understand that the idea of a safe harbor is that you want to make sure that physicians have the comfort level that before they do it, they're already going to be safe. Understand that a complaint is a complaint. We have to look at complaints no matter what. We do, of course, make sure that it's jurisdictional. We make sure that it's at least reasonable. In many instances, we ask for an explanation from physicians to at least give us an idea of what they were thinking. And even at those points, we can still dismiss a complaint. But if we do have to have it investigated, we do have those 2 physicians look at it. And again, they're looking at it based on the standard of care. So all those due processes are there and in place. It may be a little bit more exhaustive. Unfortunately, we have no ability to mitigate things from the civil standpoint or from the criminal standpoint. We hope that based on what the Supreme Court said, that everybody would at least defer to us, but we can't force that. That's not within our hands. But at least that's the attempt that we're making, is to at least put some guardrails around what it is that we're looking for, give some kind of clarity as much as we can. And I'm making some general comments here, but that's the purpose of a stakeholder meeting, right? And that's the purpose of a comment period. If the board was perfect, which we're certainly not, and those are the only certain eyes that we needed to have look at a board proposed rule, then that would be it. But just like, having 1,000 set of eyes look at a proposed rule and highlighting things that we may have overlooked and blind spots that we may not have been able to highlight, that's why we're having this process. And we are taking it to heart. We are going to take the input that we've heard, and as much as we can, with of course the constraints of the law itself, we will make adjustments. That is my assurance that I can give everybody is that we will do what we can within the constraints of the law to address the concerns that are out there as best we can as we look at the rules as we bring them in June. And based on what we do, if there are significant changes, then we may be sitting here a couple of months later with another stakeholder meeting, having another conversation about what those look like. So, but thank you for your comments and thank you for the suggestions. And I can assure you that they will all be taken to heart.
Thank you. Okay. Sarah Harrison was wanting to comment again. So go ahead.
Yeah, Scott Simpson asked about or asked to clarify whether baby B had a heart rate. Baby B did have a heart rate, so I don't know if that came across as confusing by saying baby B had a hole in his heart. A baby with a hole in their heart can have a heart rate in the womb, but not live outside of the pregnancy. So I don't know if that came across as confusing, but that's why it would have been an abortion, because there was still a heart rate despite the hole in the heart. And then Texas Right to Life proposed palliative care as an alternative to allowing women who are in my, Kate Cox's, Lauren's situation to get the required abortion necessary for our care. I reject that, and I find it inhumane and completely unserious to suggest that women go through pregnancy and experience that trauma just to watch their baby die. Obviously, the right answer is to allow the abortion and not force that kind of pregnancy and birth on a woman. So I oppose including that as a recommendation in your rules, because that's not what medically we should be offered as pregnant women in this state. But yeah, that's all I have left to say.
Thank you. Ms. Corrine Fox.
Sorry, I just was able to unmute now. Thank you. Yeah, thank you. First of all, I do want to also thank the other, all of the speakers, including the folks from the Right to Life. I do also, while I support every woman's right to the standard of care, I do also support those patients who choose a different mode of care, such as palliative care. Both are options, both are within the standard of care, and both should be supported. But it means that all care should be supportive. I have to agree, though, with the last comment that the language is very clear. In 165.8 section B, it does say very clearly, the physician must specifically document in the patient's record, and then the list of all of the things. I would like to use the ACGME guidelines for education as an example of a document where there's a little box that says background and intent, so that the intent of that document is very clear. And then there are a list of things like must do. And when we as academic fellowships or education programs, for example, are under that very close inspection by the American College of Graduate Medical Accreditation Council for Graduate Medical Education inspections, anything that is a must, we must do. Anything that is a may or recommended, there's a little bit of leeway there, and that kind of guidance within this document would be very helpful, especially for those of us who speak that kind of language, whether we're academic or in private practice, listening to the protocols, which are the must-dos, versus the guidelines, which are, there's a little bit of art and wiggle room involved.
No, I hear what you're saying. Thank you for your additional comments. I mean, again, kind of in what we were looking at is, and we can make some revisions to it. I think on our end of looking at it, when you're talking about the documentation piece, when it's saying, in addition to the requirements above, the physician must specifically document in the patient's medical record, and it gives a list, and one of them is what diagnostic imaging tests or medical literature and the answer the way we were looking at it, the answer could be none. What diagnostic testing was used? None. What medical literature was used? None. But I mean, hear what you're saying in that you're looking at it in the, okay, well, I have to do diagnostic testing. I have to do imaging. I have to do all these things. But your point's taken, and we will take a look at potential revisions. All right, last hand that's up is just M.
Hi, this is Marian Domashevsky. I'm an intensivist from Houston, Texas. Again, I support the piece on the must be documented because, as we've all seen, ACGME visits, Joint Commission CMS visits, those things are going to be interpreted as being required. My other suggestion is on B7, whether there was adequate time to transfer the patient by any means available. We have EMTALA standards. And I think that it needs to actually just state per EMTALA standards, because there also may be, if there's not an accepting hospital, we can't just ship out a patient somewhere else. So I would encourage including the EMTALA standards as part of that statement, because there may not be a place to send the patient if you don't have an accepting facility. So I would encourage including that in the language. Thank you.
Thank you. Okay, there's no one else on our list, and I'm not seeing any more hands raised as of right now. I'll give it another few seconds and see if anybody has any perhaps final comment. Okay, not seeing any. I do want to thank everyone again for their participation, whether you've submitted comments in writing, whether you made the oral comments today, or you're just here listening. This is all very important as we go through this process. And it really is helpful for us in seeing how we can potentially make some adjustments to the proposed language as is. As stated before, if it does turn out that changes to the any potential changes are substantive, then we'll kind of go back to step one of this process. We'll have to go back to the board. The board will have to approve proposed language, go back for another comment period, and we'll end up with probably another stakeholder meeting, and we'll start taking the written comments again as well. So thank you again for everyone. It's been getting close to 5 hours now, but so it's good that we scheduled the time appropriately, and we look forward to everyone's continued input as we go through this. Dr. Zaffron, is there anything you wanted to say in closing?
Yeah, no, I appreciate everybody being here and helping us in looking at things and asking the right questions. That's certainly something that we encourage. It helps us look at things in a way that we may not necessarily see at first glance. For those of you in Houston, I hope everybody's okay and that you're getting your power back, and that everybody's is safe. I know that it must have been also a little bit difficult getting on. A lot of you may not have power or internet, so thank you for making that effort and making that time. I know that this is an emotional issue, and I know that there's some very strong feelings one way or the other. We as a medical board are trying as best we can to stay within the constraints of the law, while again helping give clarity to the physicians as to how they can navigate these issues when they do happen. And as all the physicians who are listening know, medicine is a science. There is not an exact prescriptive way to handle different situations. Every circumstance is different. Every circumstance is unique. And what we're trying to do is give guardrails and guidelines, but flexibility within the variations of things that you might encounter out there. I think all the comments that were given today were helpful. We will certainly look at it. I know the board staff is going to look at it and make recommendations to the board itself, and we will go from there.
Yeah, thanks everyone again, and thank you to our staff for all the work and helping put this together. Furiously documenting what you can of the oral comments that are made, and the amount of time everyone will spend going back and looking at the video of this to make sure we didn't miss anything. So we appreciate everyone's hard work, and I'm sure we'll be discussing this some more here in the future. Wish everyone well, and we'll see you next time. Thank you.